Yes, call the list.
My lord, I take from Gowana for the petitioner, my lord.
What is the status? Demolition have been completed
My lord.
substantially, so it can be dropped. Very good. Take down. কি আছে?
Can my name, instead of my name, be learned advocate for the petitioner? Some difficulty, that is why I'm requesting your lordship.
Learned advocate for the.
Petitioner, my lord. Instead of giving Mr. Bhattacharya my name.
You are appearing. Why you are not give your name? You are Mr. Bhattacharya. Then why I will not mention your name? I can take led by Mr. Mukherjee, that I can.
That will be him.
Mr. Bhattacharya. Dispose of.
On intelligence and apology, I have mentioning from that
With notice.
with notice.
Is that a mentioning slip?
Mentioning slip with notice.
देखिए एक बार mentioning slip होगा. What is the mentioning slip? There is in a torn condition.
Torn, hardly. I just put it that notice is torn. My lord, I'm just.
What is that?
That is the notice given to the other side, both the board and the state. I'm
Fix a sellotape.
I'm after
I will take, but repair it in appropriate manner thereafter.
only that is I have done.
Give it. রোজ সকালবেলা আপনারা এসে সব করবেন নাকি? যা যা করবার করুন এসে।
My lord, I am appearing for the respondent.
Readings are complete, sir.
Everything is ready.
Let Mr. Majumdar proceed with it.
Yellow.
An affidavit in opposition has been filed by Mr. Dotto. Give me a second. That's one filing number. Mr. Majumdar, you don't want to file any reply?
I have filed already.
Oh, you have filed reply?
Yes.
কপি তো আপনাকে দিয়েছি।
Yes, I have been served with a copy. I have been served with a copy of the reply.
ভেরি গুড করলেন। এটা একটু এটা ফেলে দিও তো, তোমাদের ওখানে ডাস্টবিন যদি কিছু থাকে। কমপ্লিট। Yes, Mr. Majumdar.
My lord, the allegation against the petitioner is my lord's impersonation, that in the selection test, on behalf of the petitioner, somebody appeared, and my lord, and on the basis of that, petitioner was selected. They said that subsequently it was detected that petitioner did not appear in the selection test himself, but on his behalf, somebody appeared. That is the allegation. Now, my lord, your lordship kindly come to page 36 and
So what is the order which is under challenge?
My lord, I have challenged the order of the from the charge sheet, my lord, culminated with the order of removal from service. I preferred appeal was dismissed. Now, your lordship kindly come to page 36, annexure P1. Annexure P1. Order dated 10/11/2009.
Yes.
This is to inform you that Sri Santosh Kumar, son of Mohesh Chandra Das, TC number such and such, was recruited by Central Railway and had undergone initial training at RPF Training Center, Chinki. He was posted by Railway Board to RPSF 11 Battalion, Gadara. An inquiry was conducted based on complaint against Sri Santosh Kumar to confirm whether the appellant is the same person who appeared in the fate and participated in the written test. The document, that is his application form, answer sheet, specimen, I think, were sent to Office of Government Examiner of Question Documents, Directorate of Forensic Science, Hyderabad, for verification of documents and expert opinion. As per report of Sri G. Rajesh, Assistant Government Examiner of Question Document, Hyderabad, that the aforesaid differences are fundamental in nature and are beyond the scope natural violations, and leads to the opinion of different authorities. Hence, the documents are written by different persons. Now, my lord, this is important. Necessary action for his dismissal from service and prosecution may please be taken at your end and immediately. The entire case file in original containing such and such pages is sent herewith for bearer for further disposal, please. Who is written the letter, your lordship kindly see? Chief Security Commissioner. He has written the letter, directed the senior commandant RPSF to take necessary step for his dismissal and for further disposal. That is the Chief Security Commissioner letter. At the dictation of this letter, my lord, I was placed under suspension, page 37, annexure P2. In reference to the above, it is submitted that the detailed report against the above named constable, along with confidential papers such as received, was sent to the Inspector General RPSF Railway Board for further necessary action. Now, next important, the Inspector General RPSF by letter number such and such, dated such and such, has instructed to take the following action. The disciplinary action may be taken under Rule 153 of RPSF Rules 97. FIR may be lodged with local police. The constable may be placed under suspension immediately. So, at the dictation of the higher authority, that is Inspector General RPSF, my lord, I have placed under suspension. Next page, page 38. whereas an investigation into the charge against Constable such and such is contemplated, now therefore the undersigned in exercise of power upon me by section such and such place the said Constable Santosh Kumar E. for 11 Battalion under suspension with immediate effect. He is placed under suspension for the reason that he had taken help of other persons at the time of his recruitment and committed fraud with the government. Thus, he violated section 146.6 of RP rules. He will be allowed to subsistence allowance and other allowances in accordance with the rules. CCE company is advised that after suspension, he may be directed to report to Inspector Headquarters, Gadhara, and he will present himself daily at 6 and 20 hours daily. Inspector will ensure attendance of the above staff daily. We will deposit in accordance with CCP company battalion and will not leave the headquarters without the permission of the undersigned. So this order of suspension was placed at the dictation of the higher authority, that is Inspector General RPF. The disciplinary authority himself did not take the decision. He is placed me under suspension at the dictation of the higher authority. It is clear on record from Annexure P1 and P2. Now your lordship kindly come to charge sheet page 39.
Give me a sec. Yes.
Your lordship kindly come to page 39, Annexure P4. This is the memorandum of charge.
Yes.
The very initiation of the disciplinary proceeding on the basis of this memorandum of charge is vitiated in law. As because the disciplinary authority at the time of framing charges and allegations against me announced the name of the inquiry officer and fixed the date of inquiry himself. Your lordship kindly come to one second paragraph. Sri memorandum. Sri Santosh Kumar, lordship has got Constable such and such is hereby informed that the date for the commencement of the aforesaid inquiry is fixed to be held on 18th February 2000 at 10 hours at Battalion Gadhara for this purpose. Sri Praveen Kumar, Inspector Ekoi, number such and such is nominated as an inquiry officer who may fix up subsequent date of inquiry if necessary. Now, my lord, two things are there. The disciplinary authority himself, without asking any reply from me or any explanation, suo motu proceeded against me by fixing the date of inquiry and by appointing the inquiry officer, which reflects the biased mind of the disciplinary authority. And that point has already been decided by the catena of decision of our Honorable High Court, both single bench and division bench.
So
Well,
according to you, prior to framing, prior to issuance of the memorandum of charge, no show cause notice was served.
yes, no show cause notice was given to me. No explanation was called for. He suo motu proceeded against me with the major penalty charge sheet by appointing inquiry officer and by fixing the date of inquiry. And this matter was clarified by this honorable court, both by the reported judgment and by the unreported judgment. Well, I am placing that judgment before your lordship. If the charge sheet goes,
Give me a second.
everything will go.
Mr. Mojumdar, at this juncture, I like to put a question to you. The charges are not of insubordination.
My lord.
The charges are of impersonation. Impersonation, that means according to the authority, some other person has appeared in the examination, and by virtue of his result of that examination, you got recruitment. So in such a case, issuance of a show cause or explanation is mandatory.
My lord, lordship know that what the writ courts will find out, whether there is any deviation from decision-making process, whether there is procedural illegalities and illegalities, whether there is any violation of principle of natural justice, and whether any deviation from statutory rule. These four things will, my lord, consider the writ court. Now, my lord, my first submission before your lordship, when the inquiry disciplinary proceeding was started by framing a charge against me, it is the cardinal principle of law. High Court, in catena of decision, High Court decided, cardinal of principle of law, that you may frame a tentative decision, ask for explanation. If you satisfy by my explanation, then no question of departmental proceeding, no question of inquiry proceeding. So, it is the cardinal principle of law. You please give me a chance to satisfy you by explaining the same, that whether I am not guilty, whether this circumstances has not occurred. So, without giving me such an opportunity, straightway frame the charges according to Rule 153, that is major penalty charge sheet. That means you have already decided, your mind was reflected, that is bias. First, your lordship kindly come to the rule, statutory rule. 153.3 of RPF rules 1987.
Yes.
Lordship kindly come to Railway Protection Force Rule 153.3.
Yeah. You have the book.
I have one copy.
I don't have.
Then, my lord, I am supplying my book. I am reading, my lord. Then 153.3. On receipt of complaint
153.3
3 of RPF rules 1987.
RPF rules.
1987.
Just a minute, sir.
Sir, boi আছে?
RPF rules 19. RPF rules 19.
1987.
Rule number
153.3.
153.3. Just let me see whether it is available here or not. Chapter
That is RTF rules 1987,
chapter
मतलब chapter 9.
chapter 9.
Sorry, मतलब chapter 10.
Chapter 10 deals with uniform and equipment.
हाँ, uniform and equipment.
Page 62.
Chapter
Yes, yes, chapter 11. मतलब I'm sorry.
Chapter 11.
Discipline and conduct group. 11.
Yes.
Yes,
Chapter 11, discipline and conduct.
conduct. Yes.
এই একবার কেউ আছে এখানে? Chapter 11, no?
My lord. Then 153.3. One 53.3.
One 53.3.
3.
Yes.
My lord, I am reading.
Hmm.
On receipt of complaint
Hmm.
or otherwise, the disciplinary authority on going through the facts alleged or brought out shall decide, you lost kindly marking, shall decide whether it is a case for major or minor punishment. So, lost kindly consider this line that he disciplinary authority first, after receiving the complaint or otherwise, the disciplinary authority has to apply its mind to take decision that whether it is a major or minor penalty charge. But without taking such decision, he straightway framing that major penalty charge by appointing inquiry officer. So it is clear violation of statutory rule. He has to apply its mind, shall decide, means apply its mind. And how he will apply its mind? My explanation will consider and he will apply his mind. Thereafter, he will decide whether it is a major or minor penalty charge. He cannot straightway frame the major penalty charge without application of mind. This is violation of statutory rule.
Yes.
Now, my lord, this point was clarified elaborately by the canon of decision of our Honorable High Court. My lord, first, my lord, Mr. Justice Arun Mitro reported judgment, my lord. I am giving your lordship. This is 2000 volume 2, 2002 volume 2,
2000
volume 2, SLR Service Law Reporter, page 266. Service Law Reporter, SLR. My lord, important paragraph 11, 12, 13, 14, and 15. My lord, handing over that.
ওটা লিখে দাও পিটিশনার বলে মামলার নম্বর দাও পিটিশনার লেখো প্যারা লিখে দাও 11 to 14 প্যারা 11 to 14 11 থেকে 14
Now, lordship, kindly come first paragraph 9.
প্যারা 9
9. Let us
yes.
now let us have a look into the charge sheet, which is annexure sheet to the writ petition. In this context, at the very outset, it requires to be stated that basic principle of service jurisprudence fixed arriving at a decision by the authority as to whether a charge sheet is to be issued or not. Then and thereafter, if the authority is satisfied the charge sheet is issued, on the issuance of the charge sheet, the delinquent employee should be given a chance to give his reply stating about his defense to the allegation leveled against him. The authority is then to scrutinize and scan the charge sheet as well as the reply, and after careful scrutiny, authority is to come to a decision whether inquiry against the delinquent employee needed to be conducted or not. Then, my lord, paragraph 11, 12, my lord, the decision was quoted of the apex court. I am placing paragraph 12. Honorable Supreme Court in its decision reported in AIR 1974 Supreme Court, Krishna Chandra versus Union of India observed, it is very necessary for an authority which orders an inquiry to be satisfied that there are prima facie grounds for holding a disciplinary inquiry. And therefore, before he makes up his mind, he will either himself investigate or direct his subordinate to investigate the matter. And it is only after he receives the result of this investigation, then he can decide as to whether disciplinary action is called for or not. Next. Next paragraph. Honorable Supreme Court in its decision reported in AIR 2001, Supreme Court 343, discussed about the test of existence of bias or malafide in an administrative action and scope of judicial review in such an administrative action, and observed. The case test is as to whether there is a mere apprehension of bias or there is a real danger of bias. And it is on this score that surrounding circumstances ought to be correlated and necessary conclusion drawn therefrom. In the event, however, a conclusion is otherwise that there is existing a real danger of bias, administrative action cannot be sustained. Now, Supreme Court further observed, it is well settled in service jurisprudence that the authority has to apply its mind upon receipt of reply to the charge sheet or so called as the case may be as to whether a further inquiry is called for. In the event, upon deliberation and due consideration, it is in the affirmative, the inquiry follows, but not otherwise. Thus, where even before reply was filed by the delinquent chief secretary to the charge sheet issued against him, the chief minister made an announcement appointing an inquiry officer to go into the charge, thus indicating its mindset that the inquiry shall proceed irrespective of the reply. It cannot be said that the attitude of the authorities towards the delinquent is free and fair. In this is next paragraph 14. In this instant case, it appears from the memorandum itself that article of charges were furnished in which memorandum the authority informed the petitioner that there will be an inquiry in the same memorandum. The authority declared the name of the inquiry officer and also fixed the venue and time of the inquiry. Therefore, before receiving any reply to the alleged charges leveled against the petitioner, the authority took a decision to conduct the inquiry, and even the authority assumed the jurisdiction of the inquiry officer and fixed the venue and time of the inquiry, which clearly shows that the memorandum containing article of charges had been issued by the authority with a biased mind, and the same indicates its mindset that the inquiry shall proceed irrespective of reply, and as quoted above in the case of B.K. Khanna, such and such, observe the attitude of the authority towards the delinquent in such circumstances is not free and fair. So, my lord, the first decision, my lord, this honorable court has already clarified. Now, my lord, I am giving your lordship the second decision of our honorable court, my lord, Justice Tapobrata Chakraborty. Again, this matter came up for hearing before his lordship. This is an unreported judgment. WP number 121237 of 2007.
WP number
Well, WP number 1237 of 2007. Well, the date of judgment is 7th May 2014. Now, my lord, this point is also considered by Justice Tapobrata Chakraborty.
paragraph. Is there any paragraph number?
Paragraph,
No paragraph number.
no paragraph number is there.
Any page number, sir?
Page number 10.
ওটা দিন এই ওটা নিয়ে নোটা নিয়ে
I have heard
give me a second.
bottom,
Yes.
page 10 bottom. I have heard the submission of the learned advocates appearing on behalf of the respective parties, and I have considered the materials on record. A perusal of the record reveals that at the juncture of issuance of the charge sheet to the petitioner, the authority decided to hold the inquiry and name the inquiry officer on the body of the charge sheet and fix the date of inquiry with a categoric
Stipulation.
that the inquiry will be conducted expertly if the petitioner fails to attend the inquiry proceeding. Same thing is in this instant case also. The perusal of the statement of allegation also reveals that at the stage of issuance of the charge sheet, the respondent arrived at a positive finding to the effect that the theft of pipe took place. Well, this is not necessary. From the facts, it is appeared that the authorities had acted in a biased manner. The proposition that the disciplinary authority has to apply, your lordship kindly mark it, the proposition that the disciplinary authority has to apply its mind upon receipt of reply to the charge sheet stands reflected in the judgment delivered in the case of State of Punjab versus B.K. Khanna, reported in such and such. The judgment delivered in the case of South Bengal State Transport Corporation versus Alok Kumar Ghosh others, reported in such and such, as replied upon by the respondent, is distinguishable on facts in as much as the said matter, the charge sheet was issued on the basis of a checking conducted by the flying squad of the corporation itself. And in the backdrop of such fact and the nature of the charges, it was held that the disciplinary authority was not required to avail any reply from the delinquent employee. The petitioner admittedly did not get any opportunity to reply to the charges. Basically, Martin admittedly did not get any opportunity to reply to the charges. According to the respondent, such opportunity was not given to the petitioner as he did not pray before the concerned authority for grant of an opportunity to file a reply to the charge. Such contention of the respondent would be explicit from the averment made in paragraph 10 of the evidence opposition. Question of praying for any opportunity before the disciplinary authority to reply to the charge sheet did not occasion, since by the charge sheet the departmental inquiry was straightway initiated and an inquiry officer was appointed and date was fixed with a rider to the effect that in the event the charged officer fails to appear on the said date, the inquiry would be conducted expert. From such facts and discussion, it appears that the disciplinary authority acted in a biased manner and with a closed mind. In view of the above, the charge sheet is liable to be sustained. Now, my lord, this honorable court, my lord, also Justice of my lord Rajavasu Chaudhary also
Yes.
Mr. Justice Rajavasu Chaudhary Mansar also considered the same point and discussed, my lord,
Without a doubt.
that WPA 7899, I will supply the copy. WPA 7899 of 2008,
WPA
7899 of 2008,
899.
of 2008,
Yes.
date of judgment 13 December 2022,
13th
December 2022.
page.
My lord, now I am giving you lordship the page.
The
Start, my lord. Page 9. Page 9, my lord. His lordship has already quoted the judgment of, reported judgment of Sanjay Kumar Singh, and he has quoted everything. Then he has considered the division bench judgment. Then, my lord, your lordship kindly come. Page 10. Page 10 of the judgment, bottom. Has your lordship got it? Page 10. A similar view has been taken by this honorable court in the case of Dilip Kumar Pali. A perusal of the aforesaid judgment would make it clear that the disciplinary authority, while issuing the charge sheet, acted with a closed and biased mind. I find at the time of framing the charges, the disciplinary authority had decided to hold the inquiry without calling for any response from the petitioner. Thus, the decision to hold an inquiry was taken without giving the petitioner an opportunity to show cause or to explain. In this case, the disciplinary authority had gone even a step further and in his zeal to expedite the inquiry had also appointed the inquiry officer. It is true that the petitioner had not raised the aforesaid point in course of inquiry proceeding. However, the same does not absolve the disciplinary authority to act in accordance with law and to give an opportunity to show cause, though not specifically mandated by the said rule. The threat of bias is writ large on the disciplinary authority. It was not just an apprehension of bias, the danger of the petitioner being punished without any proper inquiry was thus real. The above conduct of the disciplinary authority thus has the effect of vitiating both the charge sheet and the inquiry. The same is liable to be set aside on the ground of appointment of the inquiry officer at the time of issuance of the charge sheet.
Give me a second, Mr. Mujumdar.
Now, my lord, I am giving back.
Give me a second.
My lord. Yes, yes. Now, my lord.
So your contention is that while issuing the memorandum dated 11 to 2010, the disciplinary authority, without awaiting for the reply of the writ petitioner or the delinquent, had straightway framed the charges, articles of charges, along with the statement of imputation,
And fix the
and
date of
appointed
inquiry
an
officer
inquiry officer and fixed a date for hearing.
with the stipulation that if you fail to attend, it will be held expert.
So it shows his close mind.
Close mind. My lord, I am
But
placing
Mr. Mujumdar, what I am asking, but admittedly, the reported decisions which you have referred in support of your contention is in your favor, at least to some extent. But in the event there are prima facie sufficient materials to go for an inquiry, whether seeking an explanation is a sine qua non, that I intend to know. That question is also with you, Learned Counsel appearing for the Union of India.
now, my lord.
Please keep it in mind that you have heard the argument of Mr. Mujumdar. When what I'm on, whether it is it can be treated as a straitjacket formula. Don't reply now. You
Right.
will get your turn. whether it can be treated as a straitjacket formula or in the event there are prima facie sufficient materials to hold an inquiry,
Right.
because the allegations are sufficient,
Hmm.
allegations are very grave,
Great.
and there are prima facie materials on the basis of a scientific report.
Right.
So in that case, whether seeking a reply from a delinquent prior to framing of the charges, that has been mentioned in the articles of charges, and imputation of misconduct, that is sine qua non or not, please reply on that.
That is not required, not under the law.
Very good. Take your seat.
Now, Lordship kindly also consider Rule 153.3 of the Railway Protection Force Rule, that on receipt of the allegation and otherwise, the disciplinary authority has to apply its mind, shall decide whether it is a case of major or minor punishment. So, shall decide means he has to apply his mind. He has to take decision. Without taking any decision, he cannot straightway frame the charge.
That you have stated already.
My lord. Now, my lord, another decision on the same point, Justice Devashish Kaur as his lordship then was, also hold that this is also clear violation of the disciplinary proceeding, and on that point, my lord, his lordship was pleased to pass the set aside as this disciplinary proceeding, that you cannot straightway hold an inquiry proceeding by appointing an inquiry officer and fix the date of inquiry. Against the decision of the Justice Kaur they preferred an appeal before this honorable court. Now I am placing the decision of the appeal court. On this case, my lord, 2 points were there. First, there was, my lord, inordinate and wanton delay in holding the disciplinary proceeding, that is fatal to the charge sheet. And second point, my lord, this point, that without asking for any explanation, you straightway holding the inquiry proceeding. So, lordship, can go through the decision of the.
It was decided in
My lord, it is my lord,
reported or unreported, sir?
unreported judgment, MAT number 80 of 2008,
MAT number
80 of 2008,
80 of 2008. 80
580, 580,
580.
of
MAT
2008,
number 580 of 2008. Page
can number 7702 of
can number not required.
Yes.
Pay,
in the case of
sir,
in-
date.
date of judgment, my lord, 10 November 2008.
10/11/2008. Sir, relevant para,
My lord, the second paragraph,
paragraph number is there or page number?
my lord, I am giving the page number. Page number page 3, my lord. I am, my lord, giving you a lordship, my lord.
My lord, my lord, subject to your lordship's kind permission, lord,
Yes.
may I interrupt? Before my learned friend proceeds further, but I am just taking 2 points regarding maintainability of the record.
So you will take that at the time of your arguments.
All right.
Yes, Mr. Majumdar.
Yes. My lord, I am reading, my lord, maybe page 3, my lord, there is no page unit.
সে দিয়েছেন উকিল বাবু?
I am reading, my lord.
Oh.
Second part of the judgment.
Where is the judgment?
Judgment, but I am giving you.
Oh,
also.
acha, acha, acha.
The judgment delivered by my Lord Justice Surendra Singh Nijjar, the then Chief Justice, and Justice Sanjeev Banerjee,
Huh.
as his lordship then was. My lord, I am reading, my lord. Then I am handing over.
Page number, sir?
His number 10.
There is no page number. Very good.
Despite bringing a charge so late in the day,
Despite
this-
bringing
a charge so late, because in this case I also took the point of delay
delay.
in holding the proceeding. That is also fatal. So that point was also discussed by the division bench as well as the point. Now I have
Why it is delay?
no. In this case I have there is no delay.
Oh, then
This case,
I see.
I argued the point in 2 points, on the point of delay and on the point of that statewide disciplinary proceedings started without giving me any explanation. to
That
the
is your main content, sir.
case. What the division bench said, despite bringing a charge so late in the day, the disciplinary authority did not deem it fit to seek an initial response from the petitioner before appointing an inquiry officer and putting the inquiry proceeding in place. The learned judge relied on paragraph 34 of the V.K. Khanna's case on the ground that before the inquiry proceeding was set up, it was incumbent upon the disciplinary authority to make a preliminary assessment of the matter. The law on the aspect is recognized at paragraph 34 of the V.K. Khanna judgment. Now, paragraph was quoted. There appears to be no infirmity on either count in the order under appeal. The appeal and application dismissed and the order impugned upon. There will be no order. So, my lord, the judgment of Justice Devashish Kaur was appealed by the division bench. Now, your lordship kindly come to the charge sheet. is annexure P4, page 41.
Page
Page 41. 41.
statement of articles of charges.
Yes. This is the charge against me.
Yes.
Now, my lord, who has framed the charge sheet? Lordship, kindly come to page 42. Adjutant means Assistant Security Commissioner. Adjutant, 11 Battalion, Gadhara. My lord, means Assistant Security Commissioner. He has framed the charge sheet. Now, my lord, what I am submitting on this point,
Adjutant means assistant.
Security Commissioner, RPF, RPSF,
Adjutant.
Assistant Security Commissioner, RPSF.
Yes.
Now, your lordship, kindly consider Annexure P1, the Chief Security Commissioner directs the subordinate authority to dismiss him and take action against him. Annexure P2, the IG Chief Security Commissioner RPSF also directed to initiate proceeding. And at their dictation, the disciplinary proceeding was initiated by a subordinate authority holding the rank of Assistant Security Commissioner.
Hmm. No, as per direction of the Chief Security Commissioner, your client was not dismissed, straightway dismissed.
No. But they direct.
He was given an opportunity to face the department
I'm
disciplinary
coming to that
proceeding.
point.
Your
What I am on-
your contention is that with the departmental proceeding was initiated without giving an opportunity to answer to the memorandum as has been issued
That is
by
my
the
first point.
first point. That is your first contention, where which shows the violation of principle of natural justice,
And bias
which
mind.
shows bias mind, and which is against the rules
Statutory rule.
as has been mentioned in
153.3.
153.3. That is your
Yes.
case.
Second point is this, my lord. The disciplinary authority himself will apply his mind and frame the charge sheet and started departmental proceeding. It is depend upon the disciplinary proceeding. But if the disciplinary authority acted at the dictation of the higher authority and framed the charge sheet, then, my lord, it is also vitiated in law. Because
Frame the charge sheet or frame the charges?
charges, because it creates influence upon the subordinate
Who
authority.
who is your disciplinary authority?
My lord, my disciplinary authority, because my appointing authority is Senior Divisional Security Commissioner or Commandant, RPSF, my disciplinary authority. So according to law, who is my appointing authority? He would be the disciplinary authority. But he did not frame the charges. The subordinate authority to the commandant.
There is a disciplinary authority according to he has not framed the charge sheet. Yes.
So my contention before your lordship is this, that commandant is the appointing authority, according to schedule of law. Commandant is the appointing authority. So he must act as a disciplinary authority.
Yes. Who has given you the punishment?
Punishment was given by the commandant.
Commandant.
I am coming to that point also. Now, my lord, what I am on, that your lordship kindly come to page 42.
Yes.
List of witnesses to be examined.
Huh.
First, Chief Security Commissioner RPF, CSP Mumbai.
Huh.
He is the prosecution witness
Huh.
and he is the de facto complainant. On the basis of this, his allegation and on the basis of his direction, I was placed under suspension and the inquiry proceeding was started by framing the charges. And he is also the principal prosecution.
So what is the wrong?
Wrong is this. Who has framed the charge sheet? Assistant Security Commissioner. But principal prosecution witness is much higher than the disciplinary authority. Can it be a fair disciplinary proceeding? When the principal prosecution witness is higher in rank than the disciplinary authority, can he act fairly and impartially? There is no apprehension of bias. He cannot influence by the decision of the principal prosecution witness, that is Chief Security Commissioner. Now, my lord, there are two things. Page 42. First is the principal prosecution witness, the Chief Security Commissioner, who is much higher in rank than the disciplinary authority who framed the charge sheet. And relied upon documents, item number 1, report of the Chief Security Commissioner. The report which was sent against me, that is also a kind of documents which was relied upon by the inquiry.
Chance of biasness or close mind.
Now, my lord,
that may be considered if the charge sheet was under challenge only. But when the inquiry proceeding has been yes, when the inquiry proceeding has been conducted and the inquiry authority has come to a finding, so you have to show that the relevant portion, that these are the material portion, these are the materials in the evidence which ought not to have been considered by the inquiry officer, but it has been considered favorably in favor of the prosecution because this evidence has been adduced by PW1, that is the Chief Security Officer. So at this stage, why the court will look to the apprehension when there are sufficient materials in the inquiry or proceeding.
I am coming one by one.
Yes, sir.
Now, my lord, who held the inquiry proceeding? Lordship, kindly come to the findings of the inquiry officer.
Yes.
Who has conducted the inquiry proceeding? Lastly, kindly come to page 43. Page 43, 11.
Okay.
Page 43, 11. I think correct. Page 43, 11.
Just a minute, sir.
And I shall go into the facts later on.
Praveen Kumar.
Parveen Kumar. Who is
Yes.
Parveen Kumar, Enquiry Officer, Inspector, Railway Material, Gadhara, presently attached with the Chief Security Commissioner, Eastern Railway, Kolkata,
Huh.
and working under ASC RPF Tilwa. So, Enquiry Officer is the Inspector. Has your Lordship got it?
Is he a superior? Not.
Inspector. So, your Lordship kindly, my point is this, that when the
Yes.
when the principal prosecution is holding the rank of Chief Security Commissioner, RPSA, then can the inquiry officer conduct the inquiry fairly and impartially, who is much more subordinate to the principal prosecution witness? That is my main point.
No, you have to, there are materials in the inquiry proceeding.
I am coming, my lord. Last year, Lordship kindly considered whether the inquiry proceeding can be sustainable in law, when the inquiry officer is much more subordinate to the principal prosecution witness, and whether there is any apprehension of bias. There can be any fair and impartial inquiry proceeding. This point was clarified by the division bench of our Honorable High Court. The inquiry was conducted by an inspector. Whether principal prosecution in the rank of Chief Security Commissioner is the main prosecution witness in this instant case, who made a complaint against me and who directed to initiate disciplinary proceeding. So, there can be any fair and impartial inquiry proceeding when the inquiry officer much more subordinate to the rank of principal prosecution witness. Thus, you kindly consider this reported judgment of our division bench. 1983 1 CLJ, 1983 1 CLJ, page 8, para 48. I am reading then on going through the various letter, documents, and evidence on record, it appears that the appellant in various applications pointed out that it was absolutely necessary to appoint an inquiry officer of the status and rank of an additional collector, as the additional collector himself is the main witness and complainant in this case. It was further pointed out that the appointment of an inquiry officer who was lower in rank than that of the additional collector and lower in position than that of the superintendent is therefore not virtually legal and correct, as the inquiry officer in such a position will be subject to a bias, and as such he will not be able to hold fair and independent proceedings, and will not be in a position to impart fair justice with an open mind, and the inquiry will be mere formality. Paragraph 48.
Mr. Majumdar, this is the quote unquote. This is a quote unquote portion. It was further pointed out that the appointment of an inquiry officer was lower. So it was the contention. What is the finding?
Finding is there. Yes, finding is
On going through the various letters and documents and such as it appeared that the appellant in various applications pointed out that it is absolutely necessary to appoint an inquiry officer of the status and rank of an additional such and such, as the additional collector himself is the main witness and complainant in this case. It was further pointed out that the then quote unquote, then what is the finding?
Finding.
This is the allegation of the delinquent.
paragraph 52.
এটা দেখি ভাই দিন 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 So have you, prior to initiation of the inquiry proceeding or even in course of inquiry proceeding, have you taken this point that the inquiry officer, you have
I
not
am a
taken that?
constable. I am a newly recruited. So, my lord, it was not possible.
So for the first time you are taking this point.
Yes. So it is the substantive question of law. Substantive question of law.
But
So-
knowing fully well that he is the superior, you participated in the inquiry proceeding.
My lord, I was bound.
No, no,
Because
have
I
you taken
am-
this
I am-
point that I want?
My lord, I am newly recruited constable. It was not possible for me to know each and everything of the rules and regulation.
Very good. Then,
Now, my lord, this point was also clarified by my lord, in the writ court, in the unreported judgment, WP 6148,
W,
P 6148,
yes,
W of 2012. Date of judgment 4/4/2012
4/4/2012.
by Honorable Mr. Justice Honit Bose, as is lordship then. Also this point.
Page number?
Your lordship kindly 2 pages, judgment,
Oh.
2 pages. Judgment.
Oh.
Two pages, judgment.
So, in this writ petition, the challenge was made at the very initiation of the disciplinary proceeding.
Yes, madam.
You appeared in this matter.
What is the principle of law was laid down by.
That I have understood.
Now against
Now, the
this
question
judgment.
which is harping in my mind,
Yes.
that the two reported one reported decision and another unreported decision, that says that if the inquiry officer is lower in rank than the principal witness, there is chance of
Bias.
fear or chance of
He will
biasness or
influenced
close
by
bias.
the decision of the higher authority.
But the question which is harping on my mind, you have not taken this point when you either during the inquiry proceeding or prior to the initiation of the disciplinary proceeding.
Yes,
That
is
was not
correct.
been
That is correct. That is correct. Because it is not possible for me. I am newly
No,
recruited.
that you have stated, sir.
Now, my lord, this judgment of Justice Aniruddha Bose was upheld by the division bench. What the division bench held, my lord, this is MAT 907 of 2012,
MAT 907 of
2012,
2012,
dated 5th March 2013.
yes.
Order passed by the then Chief Justice Arun Mishra and Justice Joy Mallavakti. What the division bench held, the single bench has considered it appropriate to order the appointment of inquiry officer higher in rank to the witnesses who is the main witness of the case to be examined. So, in this case, the main witness is the Chief Security Commissioner. So, inquiry officer must be higher in rank than the Chief Security Commissioner. We find that the order is innocuous in nature and for fair inquiry, which is bounden duty of the employer to order. Thus, we find no ground to interfere in the just order passed by the single bench. And therefore, the appeal preferred by the Union of India dismissed. This is the judgment. It is also 2 pages judgment.
খুললে বাবু উপরটাই লিখে দাও, জানো, নাহলে তো মনে থাকবে না। এটা ভেতরে লিখেছো ঠিক আছে, উপরটা লিখে দাও, প্রথম পেজটা লিখে দাও, আর ওই পেজটা ফ্ল্যাগ করে দাও, তাহলেই হবে। Yes.
Now, my lord, your lordship kindly come to page 56. Who has passed the punishment order? Page 56. Bottom. Commandant RPSA 11 Battalion.
Huh.
Now, my lord, my submission before your lordship. My submission before your lordship that it is an admitted fact and it is on record that adjutant equal to the rank of Assistant Security Commissioner framed the charge. He appointed the inquiry officer. He issued the show cause notice. Lordship kindly also show cause notice, page 50. Adjutant, he issued the show cause notice.
So cause of
Findings of the inquiry officer was supplied to me and asking explanation against the findings of the inquiry officer, page 50. And who is the authority? Lordship kindly see adjutant.
Praveen Kumar Inspector, before issuing the final order by TA, you are given a chance to submit your representation and how you are prejudiced, sir, that I want to know.
That is my point I am going to argue before your Lordship. Then your Lordship kindly consider adjutant acted as a disciplinary authority. He appointed the inquiry officer. He issued the show cause notice. So all along he acted as a disciplinary authority. But punishment was imposed by the commandant, by the higher authority of the adjutant. My submission before your Lordship.
No, come to page number 50, sir.
Yes.
Second paragraph. Before issuing the final order
I am not
by
on
the
that point, on the fact. I am not going.
no, sir.
I am questioning the authority.
Let us read, sir.
Yes.
Before issuing the final order by the disciplinary authority, comma, you are given a chance to submit your representation against the findings of the inquiry authority within such and such days on receipt of the letter of the finding. If you fail to submit your representation, it will be presumed
Within
that
the
you have
stipulated
nothing to
period,
say.
it will be presumed that you have nothing to
So
say.
that
And final order will be passed
in the
accordingly.
memo dated 7/10/2010, it has been made clear that the final order will be passed by the disciplinary authority.
Yes.
So how you are prejudiced?
Who is written this letter, your Lordship? Kindly please.
Adjutant.
Adjutant, Assistant Security Commissioner.
But he never said that I shall pass the punishment order.
He has issued the show cause notice.
Sir, I am
Admitted fact.
he has framed
Lordship-
charge sheet. He has
Lordship,
appointed the
Lordship,
inquiry officer.
let me make
He
my
has
submission.
no, sir. If I will allow you to make your submission. The adjutant has initiated the inquiry proceeding by appointing an inquiry officer.
As a disciplinary authority. As a disciplinary authority.
That I am not. I don't know. Now he has
My lord, 1 minute. Who is issued the charge sheet?
adjutant.
So the person who has issued the charge sheet and started inquiry proceeding, he is a disciplinary authority.
That is your submission.
Not my submission. This is the admitted fact. My lord, when I am issuing the charge sheet and appointing the inquiry officer to conduct the inquiry, it is the power of the disciplinary authority to frame the charge and appoint the inquiry officer.
Whether any prejudice has been caused, that I am intending.
My lord, I am not going on that point. What I am on, so my lord, my submission before your lordship.
There is a procedural irregularity.
Lordship, can I see you?
Yes.
Let me complete.
Yes.
So, adjutant equal to the rank of Assistant Security Commissioner framed the charge sheet as a disciplinary authority. Admitted fact. He appointed the inquiry officer. Admitted fact. The inquiry officer which was appointed by him conducted the inquiry proceeding. Admitted fact. He issued the show cause notice, given me a chance to explain the adverse finding of the inquiry officer. It is an admitted fact. But at the time of imposition of punishment, who is the authority? Commandant. Who is higher in rank than the adjutant, commandant. First submission before your lordship, that according to rule, if the disciplinary authority thinks that I am not competent to impose a punishment of removal, dismissal, or compulsory retirement, it is my duty to refer the matter to the higher authority, recommending severe punishment before the higher authority. That rule is there. So, assistant commandant or adjutant, he desired that I should be, my lord, deserve severe punishment like dismissal or compulsory retirement. And he is not competent, he is recommended the matter to the higher authority. My lord, recommending severe punishment imposing upon him. Your Lordship kindly consider on that aspect, my submission is this. When the original disciplinary authority recommended for severe punishment and forwarded the matter to the higher authority, the findings I am not, my lord, entitled to get the copy of the findings of the original disciplinary authority, that is Assistant Security Commissioner, who recommended for severe punishment to my higher authority. That is my submission before you.
Mr. Mojumdar, you please come to page number 51.
51.
P50.
50. Yes.
The adjutant has made it clear that before issuing the final order by the disciplinary authority, you are given a chance. So he says that the final order will be passed by the disciplinary authority. So where the question arises?
Who is the disciplinary authority? I am putting question to myself. Who is the disciplinary authority? Who has issued the
Sir,
show cause notice? Who has issued the show cause notice? You will also kindly see again.
I understand, sir. I understand your contention.
So
Your
Lordship-
contention is that
that
when the adjutant issued
issued the
the
show cause notice.
show cause notice, he framed the charges, he appointed as an inquiry officer,
He considered the findings of the inquiry officer
he acted as a disciplinary authority.
and he
But in the
also
show
given
cause
his show cause
notice,
notice.
he stated that the final order will be passed by the disciplinary authority.
Authority.
Now, I understand your contention that for all practical purposes, if I consider the entire materials as placed by you or as available in the instant file, it would reveal that for all practical purposes, the adjutant has acted as a disciplinary authority. And therefore, in the event adjutant finds that he is not competent to impose punishment, it is his bounden duty to refer to the higher authority and giving a copy to the delinquent. That is, I have understood. Sir, what I am on, sir, kindly reply on this point. I want to know that by issuing page number 50 memo, that is dated 7/10/2010, there is a explanation has been sought for by the adjutant that you give your reply with regard to the finding of the inquiry authority, as otherwise the final order would be passed by the disciplinary authority.
Disciplinary authority.
Yes.
Now, up to this stage,
So I am what I am.
disciplinary
Sir,
authority is the
I
adjutant.
understand. My question before you that whether any procedural irregularity has been caused which is detrimental to the interest of your client or not. That I intend.
Yes. So, my submission, my lord, before your lordship, that adjutant held me guilty and supply me the show cause notice and directed me to give reply as a disciplinary authority. So, my lord, the disciplinary authority, what the ultimate result is this: the disciplinary authority at the time of imposing punishment, he did not act as a punishing authority. What he has done, he recommended for severe punishment. So, my lord, first thing your lordship kindly see, the adjutant as a disciplinary authority, he has held me guilty after considering the report of the inquiry officer. Secondly, he recommended for severe punishment like removal or dismissal from service. So, two things are there. Whether even I am whole, my lord, guilty of the charges, in spite of that, my lord, I can satisfy you, the disciplinary authority, that I should not deserve a severe punishment. So, on these 2 points, my lord, I should be given an opportunity to explain before the disciplinary authority against his finding that I should satisfy your lordship that even if I hold guilty, I should not deserve severe punishment. So, my lord, the findings of the disciplinary authority, original disciplinary authority, is a part of the proceeding. Is a part of the proceeding because the punishing authority consider the findings of the original disciplinary authority and then, my lord, impose punishment. So, the findings of the disciplinary authority that is adjutant, is a part of the proceeding, and withholding of the same from me is vitiated the proceeding. Now, on this point, my lord, I am submitting before your lordship.
Give me a second. Yes.
On this point, my lord, that I am entitled to get the adverse finding of the original disciplinary authority, that is adjutant, because he recommended for severe punishment. So he has got the findings.
Where from you will get that he recommended for severe
Yeah,
punishment?
that is why how the commandant got the power. Rule says if the disciplinary authority is not competent to impose a higher punishment, severe punishment, then he will have to refer the matter to the competent authority. And on the basis of that reference, the competent authority impose the punishment. It is admitted. According to rule, it is done. Now, your lordship, my lord, on this point, your lordship can consider that is the reported judgment of my lord 1993 Supreme Court cases,
Volume
labor and service,
1993.
Supreme Court cases,
Huh.
labor and service, page 109.
Labor and service. LNS.
That is
Page.
109.
Is there any volume?
Yes, my lord. 1993 1 SCC, page
Oh.
30.
1993 SCC.
1 SCC, page 30.
1993 volume 1 SCC LNS 109.
Page 30. Labor and service, 109.
Page number?
Ah,
Paragraph number is there.
My lord?
Paragraph number is there.
Yes, yes. I am giving you lordship the paragraph. Paragraph 5.
Para 5.
Lordship need not go through the entire paragraph. Only the important part of the paragraph. I am. Lordship kindly come to paragraph 5. Paragraph 5. My lord, I am reading. It was ours. My lord, I am reading. Paragraph 5. It was ours that copy of the inquiry report having been supplied to the respondent, the rule was complied with, and the High Court committed an error in coming to conclusion that principle of natural justice was violated. Learned additional Solicitor General asked that the principle of natural justice having been incorporated and the same having been observed, the court was not justified in misinterpreting the rule. The Learned Counsel asked that bank was very fair to the respondent, and the disciplinary authority, after application of mind and careful analysis of the material on record, on its own evaluation, uninfluenced by the CBC recommendation, passed the order. It was emphasized that if the exercise would have been mechanical, the disciplinary authority would not have disagreed with the CBC recommendation on punishment. Learned Counsel submits that in any case, the disciplinary authority having passed the detailed order discussing every material on record, and the respondent having filed appeal, there was no prejudice caused to him. None of these submissions are of any help. The order is vitiated not because of mechanical exercise of power or for non-supply of the inquiry report, but for relying and acting on material which was not only irrelevant but could not have been looked into. Purpose of supplying document is to contest its veracity or give explanation. Effect of non-supply of the report of the inquiry officer before imposition of punishment need not be gone into, nor is necessary to consider validity of Schedule 5. But non-supply of CBC recommendation, which was prepared behind the back of respondent without his participation, and one does not know on what material which was not only sent to the disciplinary authority but was examined and relied on was certainly violative of procedural safeguard and contrary to the fair and justice inquiry. From the letter produced by the respondent, the authenticity of which has been verified by the learned additional solicitor general, it appears the bank turned down the request of the respondent for copy of CBC recommendation. The correspondence with the Central Vigilance Commission is a previous document communication and cannot be forwarded as the order passed by the appointing authority. It deals with the recommendation of the CBC, which is considered sufficient. Now, this very important line. Now, taking action against the employee on confidential document, which is the foundation of the order, exhibits complete misappropriation about the procedure that is required to be followed by the delinquent. Maybe that the disciplinary authority has recorded its own finding and it may be confidential, consequential, the reasoning head and basis of it, returning the findings of the guilt are same as in the CBC report, but it is being material obtained behind the back of the respondent without his knowledge or supplying any copy of him. The High Court, in our opinion, did not commit any error in passing the order. Non-supply of the vigilance report was one of the grounds taken in appeal. That was not so because the respondent tried to service of the order passed by the disciplinary authority did not have any occasion to know that CBC had submitted some report against it. The submission of the learned Solicitor General that CBC recommendations are confidential, copy which could not be supplied, cannot be accepted. Recommendation of vigilance prior to initiation of proceeding and different than CBC recommendation, which was the basis of the order passed by the disciplinary. Then, my lord, the recommendation of the original disciplinary authority, because first he held me guilty of the charges against the findings of the inquiry officer. Then he came to the finding that there are so many, my lord, there are so many punishments. I may be reduced in rank, I may be censored, I may be given another, but straightway he came to the conclusion that I should deserve severe punishment. So, on the basis of which record and how he came to the conclusion that I should be deserve severe punishment, that findings, my lord, is sufficient to me, and that was withheld. And without giving me copy, the recommendation was forwarded to the higher up. Yes.
একটু বন্ধ এখন।
Yes, Mr. Majumdar.
Yes. Now, my lord, against the adverse finding of the inquiry officer, I was directed to submit a reply. I submitted my reply. My lord, page 51 is my reply. I submitted detailed reply. Page 51 to page 55. My detailed reply against the findings of the inquiry officer. Now, your lordship kindly come to page 56, order of punishment imposed by the higher authority, commandant. Lordship, the commandant, my lord, quoted the fact of the case. Lordship, kindly see only fact of the case, and he passed the impugned order of punishment in two-line order. Lordship, kindly come to the bottom. I have carefully gone through the case. I, Lordship, kindly see inquiry report and the opinion of the disciplinary. Kindly mark it. Opinion of the disciplinary authority. What I was submitted before the court. That is adjutant. Adjutant submitted his opinion, recommending severe punishment. So he has considered the opinion of the disciplinary authority. I hereby impose the punishment of removal from service. My lord, I am asking myself, is it a speaking order? Purely non-application of mine. No point of my defense, no point of my reply was considered. Nothing was said, only two-line order. Non-application of mine, purely non-application of mine. I am referring the reported judgment of the apex court. AIR 1985 Supreme Court.
Yeah,
AIR 1985 Supreme Court. 1121 1121 1121.
Relevant paragraph.
5 and 6. 5 and 6. The last I will go through the paragraph. Very important paragraph. Five and 6. Paragraph 5 and 6, very important.
This is with regard to the disciplinary inquiry.
Disciplinary inquiry. But principal law is this, that you will have to comply each and everything. Your lordship kindly go through the order of the disciplinary authority. He imposed punishment upon me. He snatched my livelihood. Is there any reason recorded that why the
Why is accepting the report of the inquiry officer?
Yes,
That has to be stated.
nothing was done. And the same thing was considered by the apex court in the case of, well, that is also, my lord,
Give me a second, sir.
2009.
Just a
volume-
minute, sir. Just a minute.
Same thing also was considered by the apex court in the case of, my lord, Rup Singh Negi versus Punjab National Bank, reported in 2009 volume 4 SLR, Service Law Reporter. 2009 volume 4 Service Law Reporter, page 78. Paragraph 70. Paragraph 70.
Yes, that is on that.
Now,
The
my lord,
disciplinary authority must assign his reason as to why he is accepting the report of the inquiry officer. That is there. That is settled.
now, my lord, against that order, removal order, I prefer an appeal. My appeal, my lord, contains, my lord, page 57. Page 57 to 64, all are my ground of appeal.
Page 57 to 64 is your appeal memo.
57 to 64. Now your lordship kindly come to the order of the appeal.
Where is the order of the appellate authority?
Page 73.
Yes.
Page 73. The lordship kindly come to last paragraph of page 73.
Hmm.
I have carefully gone through the DR case and examined all the records on the file, including the appeals submitted by the applicant. The conclusion of the applicant that he was not issued a so-called notice before suspension is not acceptable, as no such notice is required to be issued as per RPF rules before suspension to the member of the court. Moreover, suspension is not a punishment. The other conclusion is that the complainant was anonymous, sent in the name of Buddhijeevi Brahmin, and was not to be accepted upon is also not accepted, as any anonymous complaint containing valuable facts can always be got inquired into, and accordingly in this case, proper scientific examination of the property check in the name of the appellant and his application were got examined along with other documents by the forensic science Hyderabad. And the charge sheet was issued on the basis of the evidence brought on record during the inquiry. As per fact, issue was writing its answer book by some other person, not his thumb impression. As such, the action taken by getting the disputed document examined is fit and proper as per the methodologies prescribed for conducting hearing. It is also seen from the DRK file that the appellant did not raise any objection regarding nomination of employee officer, which is clearly now and after time. Thus, after going through the appeal and the DRK file, I am of the considered opinion that the charges leveled against were proved and the punishment awarded by the Supreme Court of Appeal meets with the use of the justice. And I do not find sufficient and traceable reason to interfere with the order passed by the disciplinary authority, and accordingly his appeal was valid. Now, my lord, first you will have to comply with Rule 217.3 of RPA Rules 1987.
Rule
217.3. 217.3 of RPA Rules 1987. My lord, I am supplying my book. Your loss in need of trouble.
Oh, very good.
I will supply my book. In the case of an appeal against an order imposing any of the punishments specified in Rule 148 and Rule 149, or enhancing any penalty imposed under the said rule, the appellate authority shall consider A, whether the procedure prescribed in these rules has been complied with, and if not, whether such non-compliance has resulted in violation of any constitutional provision or in miscarriage of justice. Secondly, whether the findings are warranted and based on it, whether the punishment or the enhanced punishment imposed is adequate or inadequate or severe and specific speaking. That's what I see. 217. How the appellate authority will consider that. Either I am supplying my.
Yes.
So your lordship, can you see the concluding portion of the appellate authority? Nothing was discussed in terms of Rule 217.3 of RPF rules, and no reason was disclosed. '74 concluding portion. Thus, after going through the
Just a minute. Sir. What is DAR?
Disciplinary proceeding. Disciplinary authority.
Disciplinary authorities report.
DR rules. Departmental authority.
Yes.
And I am referring the authority AIR 1986 Supreme Court. AIR 1986 Supreme Court, page 1173.
Page
1173. Paragraph 5 and 6. Correct here.
paragraph 5 and 6. Yes.
And my lord, I am also citing another judgment on this point. AIR 1986 Supreme Court,
Give me a second. AIR
1986 Supreme Court 1040.
para
There are 4 and 5. That even 4 and 5. So these are all my submission all made.
yes.
And my learned friend will take the point of maintainability. I shall give answer later on. Let my learned friend Calcutta.
Yes. But before going into the merits of the case, my lord, I would submit before your lordship that 2 points of maintainability are very much, my lord, canvassable before your lordship. Number one is this, my lord, that the petitioner, my lord, was recruited from Nagpur, that is Maharashtra. Petitioner, who is before your lordship, he was recruited, my lord, through recruitment examination held at Nagpur in Maharashtra. Now, the entire the basis of the allegation arose from Nagpur itself, because the allegation was simple as that his answer script was written by somebody else, and after scientific test, applying due methodology, it was substantiated that the author was different. The applicant who in response to the advertisement who applied for the post, he did not write the answer scripts. Somebody else on his behalf wrote it. That is the allegation. So, cause of action, the basis cause of action arose at Nagpur. The proper jurisdiction, according to me, would have been in Mumbai, not in Kolkata, not in Calcutta High Court, rather. This is number one. But he preferred this, saying that part of the cause of action arose in Calcutta. That is his only submission regarding maintainability. In reply, affidavit in reply, the petitioner has said that part of cause of action had arisen in Calcutta, therefore he has availed the jurisdiction of Calcutta High Court. So this is number one. Number two, my lord, that point of maintainability, my lord, should be tested by your lordship whether it is at all the Calcutta High Court has the, my lord, authority to decide this matter, because my lord, the basis of the cause of action, the allegation arose at Nagpur. This is number one. Number two, my lord, at the threshold, the writ petition ought to have been dismissed at the threshold before going into or admitting the writ petition, for the simple reason, under the RPF rules, but after appellate order, he did not avail the remedy of preferring revision that is provided in the rule itself. So without preferring the available remedy, the discretionary jurisdiction of Calcutta High Court ought not have been availed by the petitioner for getting any relief whatsoever. But he ought to have preferred the revision against the appellate order. He did not do that. Admitted position, Lord. And Lord, if your lordship sees Rule 219, there is a provision clearly written in the rule that after appellate, or if the appeal is rejected, he can prefer a revision, which was not done.
Rule number, sir?
219. 219. Yeah? Yes. We have taken this point in our opposition also. So that is not adequate alternative remedy.
An enrolled member of the force whose appeal has been rejected by a competent authority
Yes.
may prefer an application for revision for the next superior authority.
Right. He
The
has
power of revision may be exercised only when such and such.
yes.
So there was a statutory forum.
Statutory forum.
So availability of the statutory
Right.
alternative remedy was there.
Yes. Alternative efficacious statutory remedy was available. He did not choose to avail that. Rather, he has taken this honorable court's forum to get relief. But this is not, according to me, subject to your lordship's kind
You
consideration.
have taken this point in affidavit. No.
Yes, yes.
Sir, kindly show me the relevant paragraph of
Yes.
your relevant opposition.
Opposition has point. Opposition.
Though it is a pure question of law, it can be raised at any point of time. There is no
Right,
doubt of it.
right. No, we have taken. Lord.
Kindly show the relevant
Yes.
paragraph, sir.
Yes, but page 7 starts from page 6. At the bottom, opposition, affidavit in opposition by the Union of India. But page 6 at the bottom, again the petitioner have filed the instant writ petition before this honorable court challenging the aforesaid
Paragraph number, sir?
paragraph number. It is a continuation. Just a minute, Lord. It's a lengthy paragraph.
In your affidavit in opposition, sir?
Yes. But paragraph 3, but, it continues from page 3 to page 7.
No, it starts from page number 2, sir.
Paragraph 3 starts from page
2.
Page 2, right?
Page 2.
Page 2 to
Now you are referring which page?
yes. But I'm just referring page 6 at the bottom.
Page 6.
Page 6 at the bottom.
I believe there is some mismatch. Page 6 at the bottom, paragraph 11 is there. একবার উকিল লোকে দাও তো বাবা এই যে এটা একটু উকিল লোকে দাও বুঝতে পারছি না কোন জায়গাটা বলতে চাইছো it is the affidavit in opposition.
Page 5, Lord. I'm
Huh?
sorry, page 5. If your lordship sees page 5.
আপনি একটা কাজ করুন না উকিলকে একবার দিন, এই ভাঁজ করে দিয়েছি, আর পেন্সিলটাও দিন, উনি মার্ক করে দিন কোন জায়গাটা আপনাকে বলতে চাইছেন। You just take my file, sir, and take the pencil and mark it. Kindly mark. I folded the first page of your affidavit of opposition. Open it, sir. Open it. Open it. It is your affidavit of opposition.
Yes, yes.
Make it. Keep it folded.
Harikant.
Keep it folded, sir.
Yes.
Keep the first page folded. Thank you.
Page 5.
Page 5.
Well, again, it starts, second paragraph, it starts again, the petitioner have filed the instant writ petition before this honorable court challenging the efforts. Page 5, second paragraph. Opposition. No, no, page 6 also.
Again, the petitioner
Yes,
filed
again
the
the
instant
petitioner have
petition
filed the
before this
instant-
honorable court,
Yes.
challenging the aforesaid order of the appellate authority. In this regard, I most humbly say the petitioner has not preferred any revision under section such and such against the appellate. Therefore, he has not availed all departmental forum availed to him as per law.
Yes. This is specific that point we have taken in our opposition.
Very good. Petitioner is resident of Munger district in
State of Bihar,
Bihar.
and the offence was committed by him in the state of Maharashtra in Nagpur district, where an FIR was also lodged against him. Therefore, the petitioner could file a writ petition either in the state of Bihar or in the state of Maharashtra. It is therefore humbly prayed before this honorable court to dismiss. So these 2 points regarding maintainability, one is of jurisdictional maintainability, another is of statutory alternative remedy point. So these 2 points regarding maintainability of the writ petition should be decided first, before going into the merits. And regarding merits, whatever has been submitted by my learned friend, I would submit that the inquiry, there is no finding by any of the authority who came to the conclusion that the guilt was committed by the petitioner, accordingly punishment was inflicted. Now, there is no flaw highlighted at any point of time anywhere that there has been violation of rule in the conduct of inquiry. There is not a single violation of any of the rules regarding conduct of inquiry. So if your lordship decides the maintainability point, not only in that case, I would just go into the merits.
No, sir, you may come to the merit portion also.
Yes.
Sir,
Now,
for the, sir, for the sake of argument, if I accept your contention that it is maintainable,
yes.
but I can still deal with the other points also.
That's correct. That's correct. If your lordship
Even if I accept your contention that the representation is not maintainable,
right,
there is no embargo on the part of the court to proceed with the on the basis of the merit.
Right.
You please
That's
continue.
now kindly see the rule 153, which
So maintainability point so
Two.
far you have raised is twofold.
right.
One is jurisdictional error.
Yes.
Another is
Alternative remedy.
availability of alternative efficacious remedy.
Absolutely.
Absolutely.
As per rule, statutory alternative.
Statutory alternative.
Yes. Now, regarding merit, kindly see rule 153. That is the procedure for imposing major punishment. So he has been removed from service by way of inflicting a penalty, major penalty. Now, whether there has been any breach with regard to procedure, subject to your lordship's scrutiny, I do not find any irregularity in the conduct of inquiry. So kindly see procedure for imposing major punishment without prejudice to the provisions of the Public Service Servants Inquiries Act 1850. No order of dismissal, removal, compulsory retirement, or reduction in rank shall be passed on any enrolled member of the force, save as mentioned in the rule, without holding an inquiry, as far as may be in the manner provided hereinafter, in which he has been informed in writing of the grounds on which it is proposed to be taken to take action, and has been afforded a reasonable opportunity of defending himself.
Yes.
Now, the inquiry was inquiry proceeding was adopted prior to inflicting the punishment of removal from service. Not that simply on the basis of scientific report regarding a different author who wrote the written answers, but the punishment was inflicted. The inquiry was conducted. Now, the fairness of the inquiry, whether there was a fair inquiry or not, very limited scope in the read jurisdiction. Your lordship is very much
Judicial review scope
yes,
is very limited.
very limited, because the on the basis of evidence.
So
And
your contention is that since the delinquent was given a major punishment,
yes,
so provisions of 153.1 was followed.
yes, was invoked, and thereafter punishment was imposed. Not that no inquiry was there, only punishment was imposed. Not that. As per procedure established by rule, the inquiry was conducted. There was a fair inquiry, and after findings arrived at by the inquiry officer, opportunity was given to the delinquent to make a representation. He did so after consideration of everything. There was no allegation that there has been violation of the principles of natural justice. So,
Yes.
if there is no violation or breach of principles of natural justice, the proceedings, the inquiry proceedings should not be interfered with.
Sir,
It is a settled law.
Then come to 153, 153 point you have referred to.
Yes.
Then kindly come to 153.2.1.
Yes, whenever the disciplinary authority is of the opinion that there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior against an enrolled member of the force, it may itself inquire into or appoint an inquiry officer higher in rank to the enrolled member charged, but not below the rank of inspector, or institute a court of inquiry to inquire into the truth thereof. So it was done. Not that the inquiry was conducted by whom? Your lordship, kindly see the cause title.
No, then who according to is the disciplinary authority?
Disciplinary authority is he was a constable, so commandant would be there is I show your lordship, there is a chart. Who is to be the disciplinary authority, who is to be appointing authority? The schedule is there, possibly schedule 3. Your lordship, kindly see schedule 3 is a schedule 1 English.
Schedule 3.
Yes. Schedule 3, your lordship would find a chart. Who is the disciplinary authority who can impose a penalty upon the constable?
Yeah. Take this.
Incomplete. But schedule 3, disciplinary authorities and their powers.
Schedule 3.
Schedule 3, this refers to Rule 25 and 133. Rule 25 and 133. Rule 25 or 130? 25 and 133. Can be true.
He was a constable.
He was a constable. But before going into the schedule, your lordships kindly sees what
Rule 25.
rule 25 at page 19 in general powers and responsibilities of superior officers. The superior officers of the force shall exercise such administrative and disciplinary powers over the members of the force placed under their command as are specified in Schedule 2 to 4, and such other powers as are conferred on railway servants of equivalent rank by any rules relating to such servants, and discharge such responsibilities as specified in these rules or may be specified in any directions issued by the central government or the Director General in this behalf. Now, your lordship, kindly come to Rule 133. Yes. Suspension.
Give me a second.
Yes.
Hmm.
Suspension. The enrolled members of the force who may be placed under suspension and the authorities by whom they may be so placed shall be as specified in Schedule 3, provided that in exceptional circumstances an assistant security commissioner may place a sub-inspector under suspension and an inspector may place any member of and below the rank of under officer under suspension, provided further that where any action is taken under the foregoing proviso, the authority suspending an enrolled member of the force shall forthwith report to the authority competent to place such enrolled member under suspension the circumstances under which the order was made and obtain his approval, and where approval is not granted, the suspension order shall become void and inoperative ab initio. For the explanation for the purposes of this rule, where an enrolled member of the force is officiating in a higher post, he shall be placed under suspension only by the authority competent to place an enrolled member or the force holding such officiating rank under suspension. Now, my lord, please, my lord, who is the disciplinary authority? And my lord, I would just draw your lordship's kind attention to Rule 148 also. Rule 1, that is description of punishments. Rule 148.3.
148.2 is a major punishment.
Right. Removal B. Removal from service. And Lord, your lordship sees 151 also. That is disciplinary, which has fallen from your lordship. Disciplinary authority.
Rule
151. 151. 151. Here Schedule 3 is mentioned.
The disciplinary authority in respect of an enrolled member of the force
Yes.
for the purpose of imposing any particular punishment or passing of any disciplinary order
Yes.
shall be the authority specified in this behalf in Schedule 3,
Yes.
in whose administrative member is serving, and shall include any authority superior to such authority.
Yes.
So
He was a force constable,
it is at rule 51.
151.
So, Deputy Assistant Security Commissioner, Assistant Commandant of RSF, Adjutant.
Then we'll kindly see 152 also.
Yes.
Authority to institute proceedings. The appointing authority or any authority otherwise empowered by general or special order may institute disciplinary proceeding against any enrolled member, or direct a disciplinary authority to institute disciplinary proceedings against any enrolled member of the force on whom the disciplinary authority is competent to impose. Under these rules, any of the punishments specified in rules 148 and 149. One 152.2 is not relevant. This is regarding minor penalties. Here, major penalty has been imposed. Now, 153 procedure for imposing penalty. Where is the breach with regard to the procedure followed by the authorities? Let him point out the breach, that this breach has been committed by the inquiry officer or the disciplinary authority or the appellate authority. No breach has been pointed out. And the number of judgments cited at the bar are not at all relevant, because unless the petitioner is able to show any breach or violation, the judgments won't apply. Roop Singh Negi cannot have any manner of application. That only substance in the argument made by the petitioner, which I find to be correct, subject to your lordship's kind appreciation, that the final order imposing removal from service is slightly cryptic, I must admit, is slightly cryptic, but it has been cured in the appellate order. If your lordship sees both the two orders, final order appears to be slightly cryptic. No sufficient reasons have been given why inquiry report is being accepted. So this should have been analysis. These are not there, but it has been improved in the appellate order. If your lordship sees page 56, the final order, which according to me ought to have been much more elaborate, which has not been done, slightly cryptic. But if your lordship sees page 72, appellate order is not cryptic. I do not find any violation in the conduct of proceedings.
And what is your contention with regard to giving no opportunity to explain the charge sheet or given reply to the charge sheet prior to the initiation of the
Well,
proceeding?
that is not required under the rule. If your lord 153, your lordship sees once again, that is not
No,
required.
that is regarding imposition of major punishment.
Right.
Mr. Mojumdar has stated that either prior to or immediately after submission of the memo, that is the charge sheet,
Yes.
memo of charge sheet,
Charge memo. Right.
no explanation was sought for from the delinquent
No,
as to why the disciplinary proceeding would not be
Yes.
initiated.
Now,
That
kindly
right?
see, that is clearly written. Kindly see what they have done. They have correctly done 153.5. 153.5. That is not required. The discipline authority shall deliver or cause to be delivered to the delinquent member at least 72 hours before the
So,
commencement
sir,
of
you are referring?
153.5.
Yes.
Now let me read. The discipline authority shall deliver or cause to be delivered to the delinquent member at least 72 hours before the commencement of the inquiry a copy of the articles of charge, the statement of imputations of misconduct or misbehavior, and a list of documents and witnesses by which each article of charge is proposed to be sustained, and fix a date when the inquiry is to commence, subsequent dates being fixed by the inquiry officer. That was accordingly done as per rule. Not that charge memo would be served upon the delinquent, then he would be given a chance to make a reply to the charge memo. Not that. Straight away inquiry date would be fixed. Accordingly, that was done. This rule is slightly a departure from other rules, Lord. Because in other cases, my learned friend is correct. In other cases, charge memo is served, then the delinquent is asked to make a reply to the charge memo. But here the rule is very specific. Straight away, the date of inquiry is fixed, then inquiry officer would fix subsequent dates.
Sir, I believe prior to reading 153.5,
Right.
You kindly place 153.4.
153.4, where it is proposed to hold an inquiry against an enrolled member of the force under this rule. The discipline authority may order that the enrolled member shall not be transferred to any other place, nor given leave without its written permission till the conclusion of the disciplinary proceedings, and the discipline authority shall draw up or cause to be drawn up the substance of the imputation of misconduct or misbehavior into definite and distinct article of charge, a statement of the imputations or misconduct or misbehavior in support of each article of charge, which shall contain a statement of all relevant facts, including any admission or confession made by the enrolled member of the force, a list of documents by which and a list of witnesses by whom the articles of charges are proposed to be sustained. So this was done. This was done. No, this is definitely a departure from other rules, because in other rules we have seen, we have experienced, your lordship has vast experience, that usually after memorandum of charge sheet is issued, that is served upon the delinquent, and delinquent is given a chance to make a representation to the charge memo. Here that
And
is
if
not
the
required.
authority is not satisfied,
Yes.
then the articles of charges along
That
with
is
the
Khanna's case.
computation,
The Khanna's
imputation of the charges.
Yes. Which
So
has been
you
referred.
are, so according to you, on conjoined perusal of 153.4 and 153.5 is concerned, there was no departure. There was no scope
There is
for
no
seeking any explanation
right.
from the delinquent
Absolutely.
under this rule.
Absolutely. Absolutely. This is therefore I don't find any violation which has been pointed out.
So
by
violation of principle of natural justice would not be occurred.
No, he never took that point. Even in his representation, he never took that point. Right. And there is.
And what is your contention with regard to the submission of Mr. Mujumdar that the PW1 is a higher official,
Right.
whereas the inquiry officer is a much lower in rank,
Right.
and therefore it is very difficult for the inquiry officer to ignore the evidence adduced by the PW1 who himself is the
But
informer. What is
yes,
your answer?
yes. My submission would be this, Lord. But the higher officer came to know about the misdeeds of the delinquent. He could have taken action himself. He did not. He directed the lower ranked officer to inquire into the matter. The Chief Security Commissioner found that there has been fraud in written examination. He himself could have taken action, but he did not do so. He directed the disciplinary authority.
Principle of natural justice for
Yes, because inquiry was conducted, and there has been no breach or flaws pointed out by my learned friend that inquiry should be vitiated for this reason. There has been violation of rule. There has been violation of the principles of natural justice. Nothing has been shown to your lordship. Only certain judgments have been pressed, but those are not relevant at all.
any other points?
No,
Sir?
regarding the judgments cited before your lordship by my learned friend, that I would only submit those cases with regard to disciplinary proceedings are settled principles of law, but he has to show the violation of principles of natural justice. Regarding Rup Singh Negi's case, which is not cited at the bar frequently with regard to the disciplinary proceedings, that if no inquiry, no reasoning is there, only in that case would apply. And on the basis of confession of guilt, if straight away action is taken, only in that case that judgment will apply. But here inquiry was conducted, sufficient opportunity was given to the delinquent. He participated in the inquiry, not that it's ex parte inquiry. He participated in the inquiry. He took his defense counsel also. He said that this defense counsel is not according to my choice, but he was allowed defense counsel.
Any other points?
This is
Wherefrom I'll get that the recruitment process was conducted in Nagpur, that is in the state of Maharashtra.
right.
Wherefrom I'll get that?
That is in the writ petition itself, not there.
Because in the cost title he has not disclosed his address.
Just a minute.
একটু কথা বলতে বাস্তবে একটু কথা বলতে পারেন কোন? Office of the Chief Security Commissioner, RPF,
Yes.
CST, Mumbai,
Yes.
page number 36.
But if you lordship sees the charge memo at page 39, your lordship would find, because allegations are there, imputation of allegations, statement of it has been reported by so-and-so Mumbai, dated so-and-so Santosh Kumar, was recruited by the Central Railway and had undergone initial training and posted to so-and-so. An inquiry was conducted based on complaint against Sri Santosh Kumar to confirm whether the applicant is same person who appeared in the physical efficiency test and participated in the written test. Accordingly, the document, that is application form, answer sheet and specimen.
Yes, yes, at Nagpur.
Yes.
Appointment for written test, appointment, different authorship during written test for the appointment of constable
Ogni-
conducted on Atho at RPF at Nagpur.
No,
Yes. Anything more, sir?
no.
Yes,
I'm
Mr.
extremely-
Majumdar, whatever, why you have filed before this court?
Lordship, kindly come to paragraph 5 of my reply.
Paragraph 5 of your reply.
Yes.
Yes, sir.
With reference to the statement contained in paragraph 4 of the state affidavit 7 except what a matter of records, I categorically deny this truth and obligation and further state that the disciplinary proceeding which help law to due to legality. Yes. Next, second paragraph. I further state that revision under section 219 of the RPF rules 1987 is not mandatory in as much as the alternative remedy is not a bar to move the petition before this honorable court. Apart from that, the scope of revision is very limited, and as such, the allegation for not preparing any revision under section 219 of the RPF rule 1987 cannot be sustainable in law. I clearly to make my submission at the point. My lord, this point came up for consideration before my lord Justice Dr. Shambhuti Chakraborty, and his lordship held, because I have no judgment head in now, but I shall produce. Justice Shambhuti Chakraborty held that revision is not mandatory, and 219. Secondly, my lord, when I moved the writ petition, they did not take this point. They did not take this point when I moved the writ petition. So at this latest stage, they cannot take this point that 219, and for such alternative remedy, well, my writ petition cannot go, because the writ court has each and every power to hear the matter on merit, and 219 is not mandatory. That was held by Dr. Shambhuti Chakraborty, deed and lordship. Now, appeal is mandatory. I have preferred an appeal, but 219 revision is not mandatory. It was held by this honorable. And this point was not taken when I moved the writ petition at the initial stage. Was not taken. So at this belated stage, they cannot take this point, and my lord, overlook my writ petition on merit.
Why are you saying belated state? They have stated in their affidavit in opposition.
No, 2012, when I moved the writ petition, they should take up the point before this honorable court at the initial stage. They did not take it. The writ petition was moved, the lordship, 7 September 2012. I moved this writ petition. And initial order was passed by Dr. Shambhuti Chakraborty. And his lordship also considered.
So in the reported decision of Radhakishan Industries versus State of Himachal Pradesh, reported in 2021, volume 6, SCC 771. Radhakishan Industries versus State of Himachal Pradesh, 2021, volume 6, SCC 771. The Honorable Apex Court expressly held that an alternative remedy by itself does not divest the High Court of its power under Article 226 of
Yes,
the
my lord.
Constitution
That was considered by the
in
Labeling.
an appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternate remedy is provided by law. When a right is created by a statute, which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be had to that particular statutory remedy before invoking the discretionary remedy under Article 226 of the Constitution. That this rule of exhaustion of statutory remedies is a rule of policy, convenience, and discretion. In cases where there are disputed questions of fact, the High Court may decide to decline jurisdiction in writ petition. However, if the High Court is objectively of the view that the nature of the controversy requires the exercise of jurisdiction, such a view would not be readily be interfered with. These principles have been consistently upheld by this court in Chandrathan case, reported in 2003 5 SCC, Babubhai Mulchibhai Patel case reported in 1974, Volume 2 SCC 706, and Rajasthan ACP versus Union of India, reported in 2008 5 SCC 632.
And 2006 Lab Ligam case.
So these judgments are staring at your face. Very good. What is your, so far as the jurisdictional point
Yes.
is concerned, what would be your
Yes.
contention?
Logically came to page 3 of my reply.
Yes, sir.
I further state that the point of territorial jurisdiction as alleged by the deponent of the said affidavit cannot be sustainable in law in view of the fact that a part of the cause of action had already taken place within the territorial jurisdiction of this honorable.
How, sir?
I have stated, it is evident from the purported order of removal from service dated such and such, whereby the disciplinary authority direct me to prepare an appeal to the DIG RPF OPS 1 KK. Thus, you kindly come to the order of page page 56. Page 56,
Page 56 of your writ petition.
writ petition. Thus, you kindly see, this is handwritten. Appeal, if any, should be submitted within 30 days on receipt of final order to DIG, your logically mark it to DIG, RPSF, OPS 2, KK means Kolkata. And am made in party. I
So,
also
it
I
is
also
a,
papered this appeal to this authority.
can it be termed as a part of the cause of action?
Yes. That's to kindly come. Two things are there. I prepared an appeal according to the
He has given me
Based
a
on the-
forum. He has indicated a forum.
yes.
How
and
the
that
part of the cause of action?
that
Arose in Kolkata.
That authority I am alert. I prepared an appeal to that authority. He is a party in my petition. Kindly come to page 5.
Page 5.
4. Respondent number 4.
Very good.
And next, logically come to respondent number 8, inquiry officer, who held the inquiry against me, submitted a report. Logically, she, Inspector RPSF, presently attached with Chief Security Commissioner RPF Eastern Railway, Kolkata. He also held the inquiry against me. And they have considered the findings. So it is a part of the cause of action.
I should take
Now,
now.
another point here also. I prepared an appeal to the appellate authority. Appellate authority was not disposed of my appeal. I moved the petition before this honorable court. This honorable court directed the appellate authority to dispose of my appeal.
Anyway, ultimately it has been disposed of.
When I moved the writ petition before this honorable court,
I understand.
that jurisdictional point was not raised.
Hearing is concluded.
Before my lord rises, Lord, I am making an unusual prayer. Kindly do not take me amiss. My lord, there are
Had there been any occasion that I have taken the amiss?
not at all, not at all.
So
But
far my recollection goes, I
am sorry.
so sir, please sir.
My lord, there are items 12 to 17. These are all a batch of matters in connection with the applicability of the Land Acquisition Act, old Land Acquisition Act, or the new act. Now, my lord, I appeal
is
to one taken, the other.
It is under the heading for dismissal.
Millard, what happened, Millard? I truly concede that Millard matters appeared.
Probably I could not, I may not be, mine may not reach today.
No, that's right. That is the only thing, because one matter has been fixed by my Lord Mr. Justice Parthasarathi Chatterjee. Therefore, Millard, I will be from two there. Kindly do not, because it is appearing.
এটা একটু mark করে রাখুন তো।
Millard, I appeal to my lords. Millard, I
12 to 17.
12 to 17.
You are for the writ petitioner.
Yes, I am for the writ petition. If it is taken up tomorrow, Millard, I will be the.
তাহলে একটা কাজ তাহলে করে রাখুন তো 12 to 17 লিখে রাখুন। ইয়া আসুন না লিখে। No sir, it is required.
My lord,
Just a minute. এই একটা কাজ করুন। এই
27, my lord, all on a sudden it appeared, my lord, without giving me any notice. My lord, I am for the State Bank of India and it's a very old matter. I have to take instruction and possibly tomorrow and day after tomorrow, due to my personal difficulty, I will not be able.
27, not this week.
Yes, much obliged.
For the petitioner.
No, my lord, I am not for the, I am for State Bank of India.
You serve a notice.
No, my lord, they are the petitioner. I am not the petitioner.
Sir, I know, I understand. Even then, I request you to serve a notice.
Yes. I will inform.
That is pending before this court.
Most probably the advocate record also has been changed. The name appearing is as he is not presently advocate on record for the petitioner. Most probably.
Very good. Let us see.
Yes. My lord, not this way. Much obliged.
just next one, 6. Today it was fixed. Kindly, my lord, fix one date as convenience.
Right. There is a 2 p.m. fixed matter. And today is also possibly 3:30.
Yes, 3:30 is.
So what is, Milord?
What I can assure you that this is a fixed matter, considering your anxiety, I shall pass no adverse.
No, my lord, I am present here. That's not the.
If a date can be fixed.
My lord.
Well, yesterday, when I was concluding my arguments, I had almost finished. I had finished, in fact. Uh, Mr. Chatterjee was kind enough to hand over a judgment order.
কালকে যেটা ছিল
order.
yes yes he was in full.
It's very kind of him to দাদা একটা কপি আছে আমার কাছে আর কেন কোর্টকে দিয়ে দিচ্ছি মানে এটা তো আপনি দিলেন আমি আমি তো শেষ করিনি দাদা আমি এখনো আপনি তো পরে করি তাই জন্য rather give this because I won't get the chance. I have not concluded. I have not concluded as আরেকটাও দিয়ে দিচ্ছি আপনাকে it's the same thing.
yes Mr. Sanna.
Yes, yesterday, when I almost concluded, Mr. Chatterjee was kind enough to hand over a judgment of a coordinate bench of this honorable court, where a similar writ application was dismissed. The grounds of dismissal was, if your lordship kindly sees that, he's handed it over. I'm saying this because I may not get the opportunity again to place another judgment contra this. Apart from other things, this was where I pointed out at page 70 to 70, 70, 71, 72, 73. Some of these candidates that was also produced before this honorable court. And the honorable court said that you have not been able to prove that these people there was no addition of party, one. And number two is that
basically the writ petition was dismissed of or not for not adding the parties.
Not adding the parties, one.
To counter that, you have referred a judgment where it has been held by the Honorable Supreme Court that adding all the parties are not necessary. That you
Not
have stated.
necessarily, one. Number two is that this Shingo, if your lordship sees page 3, Ananya Shingo obtained so many marks. Shit obtained so many marks. Pradipta so many Shantudhara. These are only 4 of them. These were in my writ petition. These 5% were in my writ petition, and I've shown your lordship that they were not selected, and then they were selected. I've shown your lordship that. So the court said that this is not of much relevance. And one more thing that the court said was that your lordship kindly comes over to page 4. The concerned recruitment process is already over and the life of the panel had also expired. Now, my contention is here that when I preferred the writ petition, the life of the panel was there. And Millard, if your lordship sees this judgment, one more judgment, Millard, 2003 8 SCC 559. 2003 8 SCC 559. Paragraph 10. This is in a criminal matter where the complaint had to be filed within 1 year. The complaint was filed within 1 year. The magistrate took cognizance of the complaint later. So it was said that this had become infructuous. Now, what the Honorable Court says, the Supreme Court says, is that it is not infructuous because, if your lordship kindly comes to paragraph 10, I think I've handed over the wrong.
It is not the correct one.
No, not the judgment is right, but that is marked. My marking is there.
Oh, I'll ignore the marking.
No, your lordship, that is the relevant point. That
Para 10.
yes, paragraph 10, the marking. I could have read it.
No, no, sorry.
I'm sorry, Here, I had preferred the writ petition when the panel was alive. So all these provisions, my underlying motion is very. All these provisions indicate that the court taking cognizance can take cognizance of an offence, the complaint of which is filed before it within the period of limitation prescribed, and if need be after excluding such time, which is legally excludable. This is our opinion indicates that the limitation prescribed is not for taking cognizance within the period of limitation, but for taking cognizance of an offence in regard to which a complaint is filed or prosecution is initiated beyond the period of limitation prescribed under the code. Apart from the statutory implications of this view of ours, we find support for this view from the fact that taking cognizance is an act of the court over which the prosecuting agency or the complainant has no control. Therefore, a complaint filed within the period of limitation under the code cannot be made infructuous by an act of court. The legal phrase actus curiae linium.
It was referred by yesterday.
And this is
I've gone through in the afternoon.
And this is what actually supports. So the panel was alive when I filed this writ petition, and by the delay in the court's proceeding, it cannot be made infructuous. So that was, and the others, Millard, after he says that, the others which have been pointed out in the third one, the first one which is there, we took inspection that was allowed by the court. That is not before this honorable court, the coordinate bench. That was not referred to. We took inspection and we found those other illegalities. So, that's.
Yes, Mr. Chatterjee. Which one I'll take first?
First, Sandeep Singh.
8618 to the 8618. First matter one.
Read with your lordship's deep.
Yes. Item number 3. 136. Yes.
However, this writ petition, there are initially the facts are very limited. When this writ petition was filed, only allegation was that these 5 persons got the lesser marks. We are admittedly get the more marks. In spite of that, they have been selected. It was initial at the initial stage. If you lordship kindly come to the paragraphs in the writ petition, there are three relevant paragraphs according to me: 6, 8, and 9. 6 is at page 11. That your petitioner who qualified in the written test were not selected even after interview. On the contrary, candidates who are not qualified in the written test and who obtained lesser qualifying marks than that specified in the aforesaid circular were dispatched appointment letter for recruitment to the post of primary teachers in 2009 of Paschim Midnapur District Primary School Council. The details of the candidate who obtained lesser qualifying marks as per result of the written test, but who were selected and dispatched appointment letters as per the final panel status are as follows. These are the status: Momota Singh, Sohan Kundu, Udipto Das, Shantanu Dhara, Ananda Singh. In the initial status not selected for interview, then final status selected. Then you'll also kindly come to paragraph 9. Sorry, paragraph 8. Furthermore, the concerned respondent authorities have by selecting candidates who have not qualified in the written test and to the exclusion of a petitioner have acted in gross violation of all procedural norms whereby the entire selection process has been preceded. In paragraph 9. The concerned respondent authorities, by adopting an unfair, illegal, contrary, and physical procedure in respect of the selection of candidates who did not even qualify in the written test but were declared selected in the final status in the panel, have acted in a highly illegal manner contrary to law, and therefore the entire process of selection, impugned procedure of recruitment primary teachers of 2009 is therefore liable to be set aside only by this honorable court. Number here I shall take only one, that petitioners have made the allegation that some persons have been appointed who are not qualified and illegally selected. But appointed and joined, there are much difference. When this writ petition was filed, till that period, it is not their case that these persons have already joined. Because after receiving this writ petition, as well as after the order passed by Honorable Justice Tandon, when the supplementary affidavit has been filed, some illegalities have been pointed out. Till that period, I believe nobody was joined, no appointment letter was issued. Selected like this in the final panel, but no appointment letter was issued. So what the question lies here, that at that stage, the identification was not there, and the persons who have been joined illegally, according to them, they have not been parties. Up to this is all right. No objection, because proving inquiry is not possible. Subsequently, after the filing of the supplementary affidavit, after the court passed the order that you supply him these Xerox copies of the panel and other documents, that changed the entire scenario. Now your lordship kindly come to their supplementary affidavit. Your lordship kindly come to the order passed by Honorable Justice Tandon. Last page of the supplementary affidavit, filed by Monsaram Mondol. Not Monsaram Mondol was advocate on record, filed by Shantanu Roy. Sumanto. Sumanto, sorry. সেটা কি next করা আছে? Appeal এটা appeal
Yes.
petitionটা কবে ফাইল করব? Now, your lordship, kindly come to the last page of the order or supplementary affidavit. Order of justice standard. The first page is relating to the personal appearance. I'm not concerned about it. Then next page. Mr. Bhattacharjee, learned advocate appearing for the council, could not dispute that the panel could be supplied if an application is made under the Right to Information Act if the said document does not come with the exception clause. There is no impediment on the part of the concerned council to hand over the photocopy of the same panel to the petitioner. Since the supply of the photocopy requires significant record, it will be appropriate if the same is supplied upon payment of cost by the petitioner. The petitioners are directed to make an application to the chairman of the state council for supply of photocopy of the panel and other document inspection whereof have been given to them with a week from date if such application is made time stipulated upon the chairman of the state council. State council supply the photocopy upon payment of cost that is for the if the cost is not paid, the state authority applies to in this matter appeals however the right supplementary evidence pointed out conformity anomaly or irregularities is alleged in the same panel state. So, my lord, the honorable court was pleased to direct the petitioners to identify what are the anomalies, what are the infirmities, what are the illegalities, not roving. Specification. Accordingly, the specification has been done. As Mr. Sandhan has pointed out, that Supreme Court 26,000, High Court 26,000, there the case is not identified. Who are the illegal appointees? Not identified. Here, for argument's sake, even if I accept that these persons are illegal appointees, that is identified. As your lordship pleased to indicate yesterday, time and again, why the entire selection will be cancelled. There are persons who have been appointed genuinely. For them, the illegal appointees, for the reason of illegal appointees, why genuine appointees will go? Definitely they will go when this is unidentified, when it cannot be segregated. But here already segregation has been done. Read petitioners have segregated these persons according to them illegally appointees. If I accept that, how many? 100 out of 4,000. Not even 10%. Even if I accept it, their contention is correct. Now you will also can see what are their statements in this supplementary affidavit. Well, I shall want to place the paragraphs from 7 to 15. That is the relevant paragraph they have indicated. Your Lordship, they have indicated that one candidate, namely Supriya Mithe, have been impaneled, paragraph 7, against serial number 580, roll number 10502973, has also been appointed. The same candidate secured 525 marks out of 800 after deducting marks of her additional paper. Her ELM marks were 439 out of 439. According to Rule 12, marks was allotted for academic qualification accordingly. Is entitled to get 439 divided 800 into 12, 6.58. They have been awarded 7.09. In this way, they have given this chart at page 4. Sit down. They have given this chart. Then you will also kindly come to page paragraph 8. Total marks in Madhyamik examination was either 800 or 900. But for some candidates, total marks have been calculated 600. Accordingly, candidates have been awarded higher marks than they are entitled. These are the Sungit, Sushant Singh, Saurabh, Sonali Datta, Sagorika, Sumanto. Well, that has been alleged. The writ petition itself, these are the 5 candidates. Against them, another writ petition was filed challenging their appointment. The Honorable Court was pleased to dismiss the writ petition because of non-jointer of parties, without going into any other matters. No appeal was taken, nothing. So that, according to me, that issue relating to the appointment of these 5 persons is no more raised. It is settled. It cannot be reopened at this stage. It can be opened in respect of others, no dispute. But in respect of these persons, no. Because
in respect of which persons?
This Sushant Singh, Saurabh De, Sonali Datta, Sagorika Bera, Sumanto Ghosh, because these are the persons. These are the persons.
Where from will get that names?
Paragraph 7. Oh, sorry. These are not same person. No, these are the persons. These are not. These are the persons. They are calculated on 600. Why this is made on 600? I shall point out from my affidavit. Later on, I shall come in. Then you will also kindly come to.
No, then what is your submission with regard to? That will deal with at the time of your affidavit operation. Very good. So far as paragraph 7 is concerned, you are saying that they have identified these persons who have been awarded marks illegally or irregularly. They have identified.
According to them, yes.
They have identified.
They have identified these persons also. Paragraph 8. Supplementary. In supplementary affidavit.
Yes, I am on that.
So here is this. Your Lordship, can you see? ঠিক আছে আমরা বলছি রেকর্ডগুলো কোথায় আছে ঠিক আছে রেকর্ডগুলো বার করো তারপর দেখো আচ্ছা নেক্সট ইওর লর্ডশিপ ক্যান গো টু প্যারাগ্রাফ 9 Though under Rule 61B of the recruitment is a candidate who has completed age of 18 years and have not completed age of 40 years as on 1st January of the year, in which the requisition for setting names of the candidates is made to the employment is concerned, only eligible for the post of primary teacher in recent years.
Mr. Chatterjee, you are reading which portion?
Paragraph 9 of the supplementary affidavit.
Yes.
I shall place up to paragraph 15.
Yes, sir. Yes. Kindly read, sir.
Achha. That though under Rule 61B of the recruitment rules, a candidate who has completed the age of 18 years and has not completed the age of 40 years on 1st January of the year in which the requisition for sending names of the candidate is made to the employment exchange concern is only eligible for the post of primary teacher. In the instant case, the selection process was initiated by an advertisement dated 30th August 2009. According to the candidate completed the age of 40 years as on 1/1/2009 are not eligible for the post of primary teacher, but the following candidates who completed the age of 40 years have been impaneled, appointed. These are the persons, 4 persons. The following 10 candidates belong to scheduled class category have been impaneled, adding higher marks for their academic qualification. These persons, then your lordship can come to paragraph 11. The panel for the candidates belong to scheduled tribe category. This is scheduled tribe have been given 3 candidates. They have been given higher marks. They have been posted to scheduled category. Am I saying though they are, oh no. It is the allegation that they are not belong to the scheduled tribe category. But even then they have been given scheduled tribe category post. Paragraph 11. No. A candidate named Sondip only was impaneled with total score of 22.99, but his name has been struck from the panel. Instead of his candidature, one Sarka Soren's total marks 22.96 have been included in the panel. Next, one Riya Chaudhary, B roll number certain have been impaneled and appointed against the post for scheduled tribe candidate, though she does not belong to the scheduled tribe category. Another candidate, Deshpande, have been impaneled and appointed against the post reserved for scheduled tribe candidate, though does not belong to the scheduled tribe category. Then paragraph 12. The following irregularities pointed out in the panel preferred for candidates belong to other backward class of categories. These are the persons. All are identified. It's not that it is unidentified persons.
Identified by the writ petitioner.
Maybe. Identified. They are the difference between the recruitment of secondary teachers in High Court as well as in Supreme Court and before the Honorable Single Judge, that the persons who are appointed in violation of the recruitment rules without getting any marks, getting 0 in the academic marks and giving false marks in the score sheet, they have been appointed. That has not been identified. Who are the persons? Because the score sheets have been destroyed. OMR sheet have been destroyed. It cannot be identified. That's why the Honorable Court come to the findings. When these are not identified, then it's not possible to.
What steps have been taken by your counsel when
Now.
these irregularities have been pointed out?
If at all these are regularities, if at all, I have not yet admitted that these has been irregularities. I say, even if I admit it, these persons will go. But your lordship, on the other hand, your lordship also kindly see, these lead petitioners never disclosed through RTI process what is their marks, whether they are above the cutoff marks or below the cutoff marks. So, recruitment process, the granting of marks cannot be challenged in the court of law. It is an absolute domain of the selection committee. So, it marks too.
I cannot follow. Kindly repeat, sir.
A selection process starts. A candidate appeared in the selection process. In the written test, he can got the answer script. He can say that I should get 20, instead of that I have given 10. This is within the domain of challenge. But in case of viability and personality test, what will be, your lordship can appreciate there are 5 persons. Your lordship has selected many persons in your lordship's life as district judge and other important functions. Many persons. There are not only 1 person, 4 or 5 persons. Difference of opinion is one will give 2, another will give 4, another will give 6, another will give 0.
It is absolutely the prerogative of the interviewer.
Interview. What I want. Now, considering all the marks, a person is appointed or not appointed. And this process is being followed from the class 4 staff to IAS everywhere, even if the judges, the honorable district judges.
Through which I have been recruited.
Even if that is also your lordship, most likely your lordship has recruited as the direct entry of additional district judge, and your lordship has given a written test and then a selection by the 3 honorable judges of the High Court panel, and what are the number your lordship received, that is published in the website. Everything is transparent.
Everything is transparent.
Everything is transparent.
That transparency is here.
Yes, this has been published in the website.
No. I will not hear you say.
Yes.
You are talking about the transparency.
Yes.
Even my scores is still available in the website.
That's right. Now it is not possible because
I'm telling you, just for the example. There are 5 subjects.
Yes.
In the written, how much marks I have obtained in 5 papers that have been there. The aggregate is also there. Thereafter I appeared before the interview board, consisting of the Honorable the Chief Justice and the other 2 senior most judges. They have given me the separate numbers.
marks.
Those have been published in the
Those are
website of the
published
High
in the
Court.
website.
That has been added.
Added.
Thereafter, the selection has
The
been done.
selection has come.
So, has it been done in this case?
Yes. Everything.
So,
Everything.
so that transparency,
Now,
they will be out of court.
now, that is published in the website. Now, when? Now, your lordship can appreciate one thing. This year, my daughter appeared in the NET examination. She secured 192 out of 400. She told me that I may not be selected. Even if I selected, I shall be in the group C, where for taking appointment in the college for assistant teacher, I have to sit for further examination. I was the impression that very well you have to make yourself ready for this. But they are maintaining a groups for study purpose. They told her, don't be disheartened. There are several questions are wrong. We are raising objection before the authority. Maybe it will be corrected. Subsequently, it appears that out of 12 questions, 6, all 12 have been corrected. 6 come in my daughter's favor. 6 is not. 6 she has written wrongly. So 192 plus 6, 198, she has got the selection. So, the error, correction of error, everywhere and always there. What I want to say, that here the selection process is consisting of interview. There are marks, IOC test and personality test as per the rules that have been awarded. That is not under challenge. Court cannot embark in inquiry on that, which candidate has given 2 and which candidate has given 8. Because I have gone through one selection process of Kalyani University, Kalyani Krishi Vishwavidyalaya, where Mr. Ranjit Chatterjee was my junior before the Honorable Division Bench of Honorable Justice Pranab Chattopadhyay. There the records are brought in. My candidates got in written test out of 100, 89, 90, all these. But in the personality test, they got 10, 2, 4 and 5. They are not selected. 90 plus 2, 92. But still, the personality test consists of 50 marks. Some persons got 50 marks, 45 marks. Maybe wrong process, but that cannot be embarked.
But the mode of awarding marks has not been disputed.
What they are saying, that these persons have got lesser marks and they were appointed. Number 1. Secondly, they are not qualified because of for appearing in the examination, there is a qualifying marks. You are to obtain these marks in your Madhyamik examination, and if you obtain these marks, considering the percentile, if you above this, you will be allowed to appear, otherwise not. These are the process emanated in the recruitment process itself. ছটফট করছিস কেন? বস না চুপ করে, যখন বলবো তখন ছটফট করার কি আছে? তো this is the process. Now what they are saying, that these are the persons who got lesser marks in the Madhyamik examination. They have been calculated for allowing them to sit in the examination instead of 800, 600 for giving better marks. These persons have been given marks wrongly in their calculation, so they have not been selected. These are the allegations. But nowhere in the writ petition, not a single line they have written that we are the persons who are above the cut-off marks. Your Lordship will not get any sentence in the main writ petition or in the supplementary act. These are the cut-out marks. Even if we are given these marks, we are above the cut-off marks. Nowhere. Because they know it. What is their marks? That is absolutely correct. Now, even if I accept these persons will go, are they will be eligible for empanelment? No. Simple answer is no. Because they are not selected candidates. They are not eligible candidates. Successful candidates. Now, my lord, yesterday your lordship has, after hearing Mr. Sannal, has opined one thing.
So you are practically challenging the locus standi of the writ petitioners.
Definitely. And I can prove it, that the allegation they have made in the supplementary evidence are all frivolous. By adducing the documents. It's not that from the air.
Yes.
Now, my lord, it is also the case of the writ petitioners that these persons have been appointed illegally, so the entire selection process should go. Entire selection process can be thrown out, can be set at naught at the first instance. When they moved the writ petition, according to Mr. Sannal, this panel was alive. Did the Honorable Court pass any interim order in their favor? Not to give any effect of the panel? No. Because there was no prior precedence. There was no balance of convenience.
Why that? That will be considered by this court now.
Now. But at that stage, there was no preventive order to us. And after the writ petition, first move was there, as there was no order. Thereafter, the appointments have been made, panel, expiry of the panel over. Panel is exhausted. Now, your lordship, kindly come to the next paragraph. This
Mr.
is
Chatterjee, consideration for passing an interim order and consideration for
final order.
for passing and final order
Are different.
are different.
I know that. But as yesterday Mr. Sannal has pointed out to your lordship, that some persons have been illegally got the benefit from the legal person who ought to have received the benefit. So these persons ought to be compensated because of the laches and negligence of the authorities. That judgment has been placed before your lordship yesterday, I believe. And your lordship also opined that, yes, if it is to be proved, then it can be awarded by the writ court, because writ court is a court of equity. But I remember this Paschim Midnapur, an appointment was challenged by some candidates before the Honorable Single Judge. Then the matter went up to the division bench. Division Bench of Honorable Justice Subrata Talukdar and Honorable Justice Lopita Banerjee was pleased to appoint at the first stage like your lordship's views. Mr. Chatterjee, if it is proved that they have been illegally prevented from joining the post, getting the salary, you are to pay the entire period compensation, the entire, all the persons, there are 12 or 13 persons like this. I say, if the court passes the order, then my clients are not duty bound. Then the calculation, my Lord Justice Talukdar was pleased to direct the learned counsel for the petitioner. Please calculate what will be the amount. They have calculated. Each person will get more than 6 and 7 crores. More than. For the entire period of the service, taking the salary, bonus and all these things. Very well, it has been deposited before the court. Then I submit before the Honorable Court. Your Lordship kindly appreciate one thing, that these persons will be appointed when these persons are qualified. Yes. Well, I cannot give any appointment to any person who is not qualified. The Honorable Court then asked me to produce the records. I produced the entire record relating to the read petitioners as well as the persons against whom the allegation has been made. Then it appears that the read petitioners not only qualified, they did not appear in the selection test. And that entire read petition appeal was dismissed with cost. That cost till that they have not paid. And my clients are pursuing their cost before the revenue authority. Till now, no cost have been paid. And huge exemplary cost have been awarded against each of the appellant.
Very good. Then come to the present case.
Now, it's not that this is the first time a matter is being brought before your lordship. This is a long-standing matter. This went up to the Supreme Court division bench. Biology Jyotirmoy Bhattacharya, sitting in division bench, also delivered a judgment on this, asking the panel to be rectified in this manner, that against the order of justice standard. That has all been, if necessary, I can produce all these decisions in respect to other issues, but relating to the self-same appointment, self-same selection process in respect of the scheduled caste and scheduled tribe. 96, whatever it may be, on the same district primary school council. Now you will also kindly come to paragraph 30. That in the panel prepared for the post reserved for ex-servicemen, 30 candidates were impaneled. Out of 30 impaneled candidates, only first candidates have been appointed. From the serial number 6 to 30, impaneled candidates have not been appointed. I am placing supplementary affidavit.
I'm also on that.
Paragraph 13, page 11. Out of 30, only 6 have been appointed, not entire thing. That is your allegation. 14. After considering the marks for academic qualification and written examination, a candidate named Pushpita Das, son of Kanchan Das, were declared not selected for interview, according to website respondents. But after interview, the self-same candidate Pushpita Das, son of Kanchan Das, have been declared finally selected in the official website of the respondent. That document was also produced by them in study. Photocopies of the information received from the official website are annexed here to it. Paragraph 15. The total panel prepared for the exempted category, following irregularities have been found. These are the irregularities. 2. So these are the allegations made after perusing the panel and other documents as directed by the Honorable Court for identification. Who are the illegal selectees? So process of identification have been done by the petitioners long back. That has been done as far as back in January 2017.
in 2017.
And these are the persons identified, not that unidentified persons. That the judgment placed before Lordship that the persons are unidentified. 2,211, 1,000 something persons are not identified. That's why the Honorable Supreme Court has observed no question of adding them, no question of sending notice, all these things. Because these are the persons. Because one judgment they have placed, I shall place before Lordship that judgment. There the Supreme Court says no notice is required to be served if the persons are not identified. So the corollary is if the persons are identified, then notice has to be served. Now your Lordship kindly come to.
So the crux of your contention is that after obtaining the copy of the
Selection
panel as per direction of the Honorable Justice Cannon, the writ petitioners have been able to
found out according to them
detect the persons who have been according to them allegedly
illegally appointed.
So that cannot have any impact upon the other persons who have been selected in the
because no allegation has been made in respect of them. And even if I accept, that's my first limb of submission. Even if I accept for argument's sake, even if your Lordship is not with me, your Lordship will be against me in respect of these persons only.
Against
these persons only, that I have been given appointed these persons who are total in number 100 to 150 out of 4,000. Not even 10%. Because total appointees were 4,000. আর তার সঙ্গে সিলেক্টের উপর যোগ কর না, মহা বিপদ।
Yes.
So these are the persons. You not even, what I am saying that entire thing can be selection can be cancelled, no doubt, if the identification cannot be done. Court cannot make any roving inquiry. It's not the function of the court. It's not the work of the court. When the identification is done, either by the petitioner or by respondent, if suppose your Lordship can say, if the petitioner has made the identification, if in my affidavit, if I do not object, do not raise any objection against that, that means doctrine of non-traverse will come. That you have not raised any objection, so you are accepting this allegation. So these persons, but that has not been done. I have given sufficient document showing that or proving that this was initial mistake, subsequently it has been rectified, and this is the real marks. And the persons who have been appointed, rightly appointed.
Very good.
Now your Lordship kindly come to my counter affidavit affirmed by Narayan Shankar. This is rather long. I have made an elaborate submission. Shall I give the paragraph number to your Lordship or I shall place?
No, sir, place.
Place. Then your Lordship kindly come to from paragraph 4I to XB. In all paragraphs, all are important. Paragraph 4I is not required. Paragraph 4II. I say that the selection process started in the year 2009 for appointment to the post of assistant teacher in primary or junior basic school under the Paschim Midnapur District Primary School Council. I say that after obtaining all formalities, written test and interview of all candidates were held and the panel was published on 24/4/2010. Your Lordship, can you mark that date?
Yes.
Now your Lordship kindly come to the writ petition itself. Sanjeev Singha. That's why this is very important. 24 June 2010, beyond 1 year.
Page number?
Read petition, page 20, the affidavit portion. That's the date of filing. তোমরা রিট পিটিশনটা ফাইল করেছো 24শে জুন 2010, যা তোমার অ্যাপ্লিকেশন মারা রয়েছে সেইটা। আর প্যানেল অ্যাপ্রুভ হয়েছে অ্যাকর্ডিং টু আমি 24/4/2010। তোমাদের মতে আমার বক্তব্য হচ্ছে
Panel was published on 24th April 2010.
yes, final panel
Huh.
after approval,
Huh.
unless the Commissioner of School Education or the then Director of School Education approved the question of publication of the
So
panel.
what is the lifetime of the panel?
1 year,
So
unless it is extended by the government.
it is a, it
is
remains
expired
valid
on
up to 23rd April 2011.
Yes,
So
so it is within the period.
huh.
It is within the period 24 June 2010, within the period. Within the period.
Then
And it expires on 23rd April 2011.
so within time.
Within time. Yes, I'm sorry, I made the wrong calculation.
Paper publication on 15th of June, the panel.
Yes, it is within time.
Within time.
Hmm.
Now, dear Lordship, and listen. What I am reading, I say that after obtaining all formality written test and interview of all candidates were held and panel was published on 24/4/2010. Accordingly, the appointments were given to the candidates who became successful in the selection process. The petitioners challenged the selection process, but they have not impeded the successful candidates to get appointment, and as such, the petition is not going to the consideration. The council, along with other corporate bodies, publish the notice and other particulars in the website called this. Petitioners themselves have managed the document downloaded from the website. After publication of the result of the initial result of the written test, the same website 24/4/2010, several complaints were received by the council as to the mistake in posting of the result in the website. On inquiry, it was found that there were some inadvertent mistake in posting the result of the website. I state that the council took legal opinion and was advised to rectify the mistake. The selection committee accordingly resolved to rectify the mistake. I further state that the correct list after rectification of the mistake was published in the report of the council as well as the website on 17/5/2010 and 18/5/2010. Respectively, I also state that such material facts and the documents have been deliberately suppressed before the Honorable Court, which amounts to fraud on the Honorable Court on the ground of suppression of material facts. The documents of the petition, facts, the petition is liable to be disputed. Then your Lordship can come to. দেখাচ্ছি আমার মনে আছে বাবা, তো ছটফট করে মামলা করে দেয় না। Then your Lordship can come to paragraph B.
Clause V.
The clause B. The petitioners have participated in the selection process being unsuccessful candidates that have no local standard to file the petition they are liable to. Then your Lordship straightway kindly come to paragraph X. Clause X.
Yes, sir.
I submit that the typographical mistake can be rectified for fair selection and the council hearing took steps for correction of the inadvertent typographical mistake for posting website. And after correction of the candidate's name and identified including the other candidates who were called as written, I further submit that the committee corrected the inadvertent mistake not for avoiding but for illegal intention. Xerox copy of the report regarding the panel 2009 along with the legal opinion and later dated 12/5/2010 are annexed here to correct the functions and correction. You also can come to page 20.
Page 20.
20. After publication of the result of the review test in the website called for www. on 24/4/2010, some complaints were received by the council as mistake of on inquiry, it was found that then there were, it would be not then, that there were some inadvertent mistake in the posting of the result to website. Then the council took legal opinion of the panel advocate of the council at Calcutta High Court and was advised to rectify the mistake. The selection committee accordingly resolved to rectify the mistake. The correct list after rectification of the mistake was published in the report of the council as well as the website on 17/5/2010 and 18/5/2010. Then you will also kindly see next page the legal opinion. Then the rectification. This is the rectification in respect of these 4 persons whose appointment was under challenge at the initial stage of the writ petition. Page 20. Their casts have been given.
Page, sir, page.
Page 24. Marksটা কি? তারপরে সাবমার্কসটা আরে ভাই সেকেন্ড কলামটা Can you see everything have been given in a transparent manner? What is their caste? What are their marks in each subject? Subject marks, IOBC test, AP score, everything. And whether selected or not, that has also been given. Yes. Yes, 12th May has been opinion was published. Then this was corrected and it is finally published.
Published on 22nd June.
Yes.
Subsequent published. Corrected the May published.
No, সেটা মেয়ে তো অন্য জিনিসটা পাবে
Is 14A. After rectification, but it's published on 17th.
যেটা মিস্টেকটা কারেকশন করে এটা পাবলিশ করলো 17 শুধু রিটেন টেস্টের এটা পাবে 17/5/18
Mr. Jari, do you require time
No,
to come ready?
No, I ready. Make myself ready.
Oh.
He asked me something, that's why I'm giving. That this is the thing. Kindly go through this. Now,
kindly allow me 30 seconds because Manoj, if 17th May 2010, as was initially said, this is a publication of result.
No, sir. You take your seat.
I'm confused. That's
I have heard.
okay, Manoj.
Let
Now-
Mr.
now-
Chatterjee may make his own submission. I will record that. Thereafter, I shall come to a finding.
no.
Rightly or wrongly, I shall come to a finding.
Yes.
I don't require your assistance.
Now
At
your
this
lordship,
stage, at least.
now your lordship can see these are the correct list. Against that, the writ petition has been filed, and that is the order placed by my landlord.
Against that,
Writ petition was filed, but the honorable court has dismissed the writ petition. This is a non-joint right.
this one,
This one.
Justice Chakraborty. Yes.
Then your lordship kindly
Just
come
a
to.
minute, just a minute. এই খুললেন কোথায় আছে? আর এদিকে আসুন, এদিকে আসুন। এটা বাই পিটিশন আর হবে না, এটা হবে হচ্ছে বাই কাউন্সিল করুন।
No. It is my paper. I have given to them for go through. Oh, by council is that's right.
ওটা কাটুন, আপনি কেটে দিন না,
কেটে
বাই
council
পিটিশনারটা কেটে বাই কাউন্সিল করুন।
It will not be finished today because of 3:30.
আরে ভাই কাউন্সিল নয়, কাউন্সিল, দূর স্পেলিং জানেন না?
ডিস্ট্রিক্ট প্রাইমারি স্কুল কাউন্সিল
DPSC করে দিন না।
COUNCIL। আমার থেকেও ইংরেজিতে খারাপ। কাউন্সিল মানে লয়ার, আর কাউন্সিল মানে হচ্ছে একটা বডি। Yes.
Now your lordship kindly come to paragraph XI, page 6. I further say that on the same cause of action, one writ application DWP number 19133 W 2010 Paul versus DWP and others, moved before the Honorable Court and on 4/3/2012, the said writ petition was heard. Before his lordship, the Honorable Justice and after the party writ petition. Now your lordship kindly come to the copy of the order, page 25. The writ petition was initially taken up for consideration by this court on 21st February 2011, when this court directed the District Primary School Council proceeding to file a report stating the actual status of the writ petition as well as an answer to the allegation that some of the candidates who have nominated lower marks than the writ petition have been given appointment. Same thing. Whatever the said order dated 21st February 2011, the District Primary School Council has filed such a report. Upon perusing the report, I am satisfied with the explanation in the council. So far as the allegation made are concerned, it has categorically stated in the report there were certain mistakes while posting the result of the candidates who participated. Right. From the report, it further acted the council to legal opinion. Accordingly, rectified the mistake and published the same notice board of the council as well as the website. In such circumstances, it is clear there is no element of bona fide involved in the involved, and the council have taken corrective measures to rectify the mistake that may have inadvertently crept in. The writ petitioners are thus not entitled to get in the as prayed for. Writ petition is liable to be dismissed and hereby dismissed. So writ petition was dismissed when the allegation was more or less the same. Oh my God, this writ petition have been moved by the persons who have been moved this writ petition. একই ব্যাপার। This writ petition was also moved against the person against whom the allegation have been made in this writ petition that they have been given appointment illegally. This Sandeep Singh and others. No, Sandeep Singh, no? This Ananda Singh and others.
সন্তু ধারা, অনন্য সিংহ, মমতা সিট, প্রদীপ্ত
Yes.
দাস, সোহম কুন্ডু।
Against the same person. Same person. So, the writ petition filed against this person এদের নামে কি করে হবে? এটা 21শে ফেব্রুয়ারি 2011, এটা কপি। ও মানে I am told that this writ petition was moved challenging page 24. আরে দাঁড়া না, page 24 challenging this. You
Then,
Lordship, can you
what
see?
is the subject matter of WP number 14650, which has been disposed of by Justice Chakraborty?
This is also the same subject matter, same issue. Same issue. Now, Your Lordship, can you come to paragraph XIII, page 8. I say that in pursuant to the earlier order passed by this Honorable Court, I supplied the copy of the panel to the petitioner, and thereafter the petitioner filed a supplementary after scrutiny of the same panel. For the Honorable Court, they alleged that 100 candidates of the panel were given higher marks than the actual one in the academic school. Therefore, the Honorable Court.
Mr. Chaudhary, I'm sorry for interruption. Which place here? Which version? Page number?
Page number 8.
Clause 13.
13.
Clause.
Earlier order passed by the Honorable Court, I supplied the copy of the panel to the petitioners, and thereafter the petitioners filed a supplementary affidavit after scrutiny of the same panel before this Honorable Court, and they alleged that 100 candidates of the panel were given higher marks than the actual one in the academic school. Thereafter, this Honorable Court has pleased to grant the final affidavit of a supplementary affidavit filed by the petitioner for the purpose of filing the affidavit of the same panel. I formed a committee of 5 men of this council, and after scrutinization of the same panel, they prepared a report of charge, wherefrom it reveals that there are some irregularities in the same panel. I say that on 14/9/2008, during his disciplinary instruction and opinion in this regard, the copy of the report is page 27. Your Lordship, kindly come to page 27. This is the forwarding letter. All the names of the writ petitioners are there.
Yes.
136,77 and 8070 Tomal question. But this is not Pradeep Kuchai's name is not there.
Huh.
The name is not there. Now, Your Lordship, I think with reference to the above, I like to inform you that there are some candidates who were participating in the recruitment of primary teachers process in 2010. I writ petition challenging the panel of the primary teachers 2010, which was approved by your office in the month of June 2010. The copy of the panel was given to the petitioners by the order of the Honorable High Court. The petitioners made some allegation in the supplementary affidavit after scrutiny of the panel. They mainly pointed out about 100 candidates of the panel who were given higher marks than the actual one in the academic score, only in the academic score, which is quietly true. This list of the same candidates of the panel are included here for your reference. The reply has to be given the Honorable Court in reference to the supplementary affidavit filed by the petitioner. So, in this circumstance, you requested to give an instruction opinion regarding the above matter. Wrong calculation in score as per notification 76 on 24/2010.
It is that clause.
As per notification.
No, clause.
Clause. No. It is in page 27.
Oh, acha.
This is the annexure.
Yes.
So, this is the acceptance of the chairman that there are some mistakes, rectification has been done, that has been sent to the office of the Commissioner of School Education for his verification and necessary instruction whether the calculation is correct or incorrect.
No. By issuing page number 27,
yes,
the chairman of the council has sought for instruction
from the
from the
Commissioner
Commissioner of School Education in respect of 100 candidates who have
Or
been
of the
given higher marks than the actual. What to do?
Supplementary affidavit has been filed
Huh.
indicating that mistake have been committed. Am I clear to your lordship? The District Primary School Council chairman, after receiving the supplementary affidavit, formed a committee of 5 persons.
Yes.
They pointed out that yes, there are
Some irregularities in the panel.
in the academic marks. Granting academic marks in the panel, not interview and
Yes, academic. They mainly pointed about
academic
about
marks.
100 candidates of the panel who were given higher marks than the actual one in the academic score,
Academic
which is
score.
quite true.
Because there are 3-4 part components for final selection.
Huh.
Academic score is also one of the component.
Huh.
So in respect of academic score, the mistakes have been committed. In respect of 100%.
So what has been done thereafter?
Now it has been corrected and sent for opinion before the Commission of School Education. Whether the correction has been done in accordance with law or not. Because you'll also can see last line of the page 27. So in these circumstances, you are requested to give me necessary instruction opinion in regarding the above matter.
I have understood, sir. What have been done?
Now you'll also can come to the next page, page 28. This was sent. Along with this letter. This was sent. Here your lordship kindly see. I am only indicating the Khudiram Pal name was the first name in the supplementary affidavit.
Marks awarded 7.76. Remarks actual marks should be 7.245.
This is also not correct. Commissioner said these are also not incorrect. You correct it again. This was sent to the commissioner for correction. These draftsmen of the affidavit ought not to have been given this because these are not relevant. This has been confused to me also. I was in the impression at the first instance why these two code sheets are there in respect of same person. Then I inquired from Mr. Shah. What is this? While preparing my note. Then he clarified that this is the correct one, this is the incorrect one, next one is correct one. As per the order of the commissioner, this has been made correct. Now your lordship kindly come to paragraph page 9, X1, 14. Page 9. I say that the said panel was scrutinized by the Office of the Commission of School Education and it was found that there was a mistake in respect of posting ELM marks. That is why not elementary marks, because in Madhyamik examination, I have not sent for the Madhyamik examination. My sons and daughters sit for the, not Madhyamik, my daughter for Madhyamik, son for ICSE. So I have seen it that out of 800, 600 is the ELM. All these things, science, mathematics, all these things. And additional subject, there are 200 marks or 100 marks, as the case may be. When my son sits in the examination, other friends are sitting in the Madhyamik examination, they are on the 700. When my daughter came, then it is 800 because there are 707 elementary marks, elementary subjects. Time to time, it has been, course has been changed. Initially, it was 600, then it was 700, 800, then it is 700 in this way. Initially, it was taken up for consideration for admission in the class 11, all the 5, then it is best of 4, best of 5, now it is best of 4. All these things have been changed from time to time. So, there are no fixed parameters or fixed guideline in this. Time to time, it has been, each after 10 years, it has been changed. So, my dear Lordship, I have now kindly come to page paragraph 9, X1B1. In this panel, I say that the panel was scrutinized by the Office of the Commission of School Education It was found that there was a mistake in the mark, although the calculation of the awarded mark was correct. As such, the office of the Commissioner of Schools directed to chart prepared by me. Accordingly, another chart was prepared, and the same was submitted to me again before the Commissioner of School Education. Now we will also kindly come to page 31. That is the corrected chart. You will also kindly see only one, first Khudiram Pal. Everybody have been corrected. Total marks obtained in Madhyamik 565. Then total marks in Madhyamik examination 800. ELM marks 483. Marks awarded in the panel 7.76. It was earlier. Now it was corrected. Wrong ELM marks in the panel, actual marks 5.17.
Wrong ELM marks in panel.
517. 517. It was calculated 483. Wrong adding. It will be 517. And 517 by putting that formula, it will be 7.76 out of 800. What the actual marks?
Then what happened with Srikanto Pal?
You will also get Srikanto Pal, wrong MP posting of MP total marks. Actual marks is 900. It will be on 900 total marks. At that stage, examination gone up to 900. He got 627. Everywhere we have the original document. If you will also so please, I can file it by a bunch. All this. You will also kind of see Srikanto Palta দেখা. You will also kind of see দুটোই দেখা. You will also kind of see both this, the front page. এই তো front page mark sheet and the front. The calculation they made in the front.
দেখি রে দেখি গো কি আছে একটু দেখি দাও।
একটু দিন তো এটা। এই দুটোই দিয়ে দিন। আরে দে না বাবা দুটোই দে। কিছু বলাবে না। You will also kind of see the first one. Khudiram Pal.
এটা শ্রীকান্ত পাল। দেখি ক্ষুদিরামটা কি আছে।
Next page is the mark sheet. And front page, the authority have calculated the marks in red ink.
Wrong ELM marks have been given. It should be 517.
Yes. And this calculation marks awarded in the panel is correct. So what they have done, they have calculated on 483. If your lordship so pleases, I can file all Xerox copies. There are 68 persons. Entire 68 persons have been given the correct one. Calculation করে দিচ্ছি আপনার শুনছি না calculation করে calculation what are the calculation করে দিচ্ছি সব 48 যোগ হবে সবাই জানে হ্যাঁ কারণ এটা অরিজিনালি করেছিল 48 যোগ করে 565 করেছিল ও না মাধ্যমিকে মার্কশিটে 565 দিয়েছে addition, পুরো 82 বাদ দেন 30 ফুটটা তাহলে যোগ হবে ঠিক আছে
দিয়ে দাও
all 68 we have in our custody because I brought all these things from the DPSC. Rather, my learned juniors brought all these things from DPSC. So, yes, they have, when they filed the supplementary affidavit, they showed this mistake. But these mistakes have been rectified and these mistakes have been disclosed in our affidavit by adducing the document. Page 31 to 33. This is the document. If necessary, I can produce also the original mark sheets and other things. আরে যেগুলো এই 68টা 68টা So these persons have been identified by them long back in 2017 after the order of justice statement. It's not that they have been identified yesterday only. Now your lordship kindly ask them, both Mr. Jahan and Mr. Sannal, what steps they have taken for early hearing of the litigation and for improvement of them. Not a single one. They did not send any notice to us for inclusion in the list. They did not send any notice to the District Primary School Council office if we are not available, that we will mention before this honorable judge for inclusion in the list. No. And how this matter has come? All on a sudden from the department. Nobody mentioned this thing.
Because they're wrong in the department.
No, I am not. They say that this is the fault of the court. I want to indicate that there is no fault of the court. It is the fault of the parties.
No.
Who
Mr. Sannal's contention was that if on account of heavy business of the court or heavy schedule of the court, the matter get delayed, it does not mean that the writ petitioner would not get justice. That would be the contention.
I could have accepted that contention if a single step has been taken by them for inclusion in the matter in the list. And if they can show that matter was in the actually list for such and such long days, but matter could not be taken up due to heavy business of the court. No such thing. Well, I used to do the matter for the petitioners also. For the respondents, my appearance is very, very less. Mr. Jahan knows and Mr. Sannal knows. My actual identification in the High Court floor, I am an advocate of the petitioners, for the petitioners, not for the respondent. Sometimes respondents brief me. a special council. Sometimes.
What makes you to change the side?
No, not changing side. Not sometimes there are certain requests from certain corners, because your lordship knows now in this present government, I have my three close friends. One is minister, one is MP, and one is MLA. If they made the request, I cannot throw them out.
Anyway, I'm not accusing him for appearing.
So my lord, this thing, I know how to carry out, how to conduct a matter. It's not unknown to me. In my 42 years of career, not a single matter is pending in my chamber. It has also happened in many of the years. Matter filed in January, matter ended in May, in June. After the exchange of affidavit, after protracted hearing before the honorable judges. And the learned advocates are to very vigilant for this thing. It is my teaching of my guru, late Arun Prakash Chatterjee. If you are vigilant, your client will come to you. If you are not vigilant, your client will not come to you. So, my lord, did they take any steps for inclusion of the matter in the list? No. Did they show any document that matter was in the list of 2019 before honorable such and such honorable judges? No. So, my lord, yes. One, it is in the list of Honorable Justice Kapoor. He did not appear. And after waiting for 3 days, His Lordship Kapoor was pleased to dismiss all the applications. So, my lord, may I stop here? Because the resolution is there. Mr. Jahan knows what is the effect of this resolution. No, 10:30 another matter is fixed.
But after paying 17,000 cost for the delay, the DPSC making the argument before lordship.
Maybe. Maybe.
Today is 26.
Today is 26. No, 27 is not possible. Your lordship kindly
31st March, that was holiday.
proposed holiday for Idujjoa.
Eid would be there.
Idujjoa এখনো declare হয়নি।
আমরা 31 এই করব চিন্তা নেই এখন।
ওটা রোববার হবে। My lord, your lordship kindly make it on first.
তাহলে এপ্রিল ফুল করে দিচ্ছি।
Second good.
এপ্রিল ফুল।
Second good.
2 p.m. 2 p.m. 2 p.m. Okay.
Next day, for Monday's day.
উনি বলছেন না
amendment করতে পারে করতে না কিছু বলে কিছু বলে কোড সিম্পল করতে অ্যাপ্লিকেশন allowed কোড ধরে নিচ্ছে
না পরবর্তীকালে ওই অ্যাপ্লিকেশন গুলো তো ডিসমিস করে দিয়েছে সব।
অ্যালাউ করলে বা ডিসমিস করবে, অ্যালাউ করলে তো ডিসপোজ অফ হয়ে গেল তখন।
আরে এই যে প্রদীপ কুচাই সাপ্লিমেন্টারি অ্যাপ্লিকেশন একটা
Mr. Chatterjee, that is the main reason for which I insist the learned members of the bar to conclude the hearing preferably in a day, or if it is not possible, in the consecutive
I was
days.
the impression I shall
In the
follow-
consecutive days, otherwise, if the in the when determination changes, it really poses a real difficulty.
I was on the impression that I may conclude today if I get 1 hour more, up to 4:30. What can I do? That's not in my hand. And tomorrow, the matter has been fixed earlier, before just Honorable Mr. Subra goes. Nobody will leave me.
এইটা যেন হারিয়ে না যায়। চল।
ভাড়া করেছি। বুঝতে পারছিস না, এটা